Yes, Mr.
Your Lordship,
Lordship may remember, my lord, I moved a motion a few days back with regard to the custody right. Not custody, visitation right. But the child, my lord, is suffering from autism. And my lord made a prayer before your lordship just to bring both the husband and wife with the child. Your lordship can do something. But the matter is appearing in the list in such a position that in 2025 it won't reach.
Saturday. This Saturday I'm fixing.
Don't punish me like that.
Your Lordship, mine is in the.
No,
Any day, my lord, at 3 p.m.
all right, handover. Ask your junior to hand over the slip. Mentioning the urgency.
I'm for the mother and the child, Your Lordship. There is a visitation order, an interim order from the court. And in between this, the lower court, the court below also is giving some orders, confusing orders. And my
Hand over the slip.
Yeah.
Please mention the urgency.
It's already there.
Listed motion, This is listed motion. Please don't mention today because after the monthly list is published, please come on next Wednesday. Please hand over extension of interim order first. Extension of interim order. Please hand over the slips.
Under certain circumstances, but I was
Please wait. Hand over the slip for extension of interim order.
But we are permitted to mention one matter.
Please wait. Please wait. Extension of interim order. Anyone? Now upgradation. Those who are Saturday, please hand over the slips.
Except me.
Please. No, those it is Saturday date bole likhe rakhun. Those who on Saturday, 2nd of August, please hand over the slip.
Yeah, my lords, kindly.
Provided there is other side, you have to notify the other side.
But there is no caveat.
All right. If there is no caveat, you will not. If there is other side, you have to. Eta shop 2 tarike kore deben. All these 2nd of August, anyone who is willing to move on 2nd of August? Please.
2nd August, no. 2nd August, no one had.
2nd of August. Only 2nd of August. Yes, Mr. Bordon.
2nd August.
You have other side, Mr. Bordon. Please notify the other side.
Maybe even one of the matters is fixed on 2nd.
Oh, it's that matter. Mr. Chatterjee is appearing.
Second August.
Yes. Yes. Other upgradation, please come on next Wednesday after the monthly list is published.
But I have
Your lordship knows one matter. The matter was heard out by your lordship on 16/7.
What do you want?
On 16, just there is an objection by your lordship that I'm liberty to given to mention the matter in the inclusion in the list. Just in
What do you want?
inclusion in the list.
Please come on next Wednesday because the monthly list will be published on Monday.
My lord's order. My lord's order is there.
It cannot be included in the list because only 2 days left. Please come on next Wednesday. I will consider other.
for correction, my lord.
2nd of August, those who are willing, only
Correction. For correction. One mistake not on our part.
please wait. Let 2nd of August be finished. Upgradation 2nd of August, please.
My lord, next Wednesday. We will approve your order to next Wednesday.
I cannot hear.
I am praying for upgradation of the only for expeditious hearing.
Anything 2nd of August, those who are willing, please. 2nd of August, Mr. Bera, please hand over on the next day.
Next Wednesday.
Next Wednesday. 2nd of August, please hand over the slip. Yes, Mr. Ghosh.
My lord, on 27th, 22nd July, your lordship passed an order.
Correction is required.
Correction, my lord, your lordship directed the matter, the interim order till September, and the matter is directed to appear after 12 weeks. That is much later.
Much later.
Yes. And my lord, your lordship, that's another mistake on our part. The name of the opposite party, instead of Proceed, it has been typed as Proceed. Your lordship kindly grant us.
All right. Let it appear under the heading to be mentioned for correction.
Lord, tomorrow, my lord.
Mention a minor
Tomorrow, my lord.
certified copy of the orders for the civil revision. There has been a tear while standing in one page. My lord, kindly grants me leave to file this. I will obtain a certified copy of that particular order separately.
To file with the server copy. Yes.
But I have got very urgent, my lord. But you know, your lordship knows cannot go beyond the deed. In this case, my lord, it was resolved up to High Court since you remember already.
That matter is appearing in the monthly
It
list.
has been filed yesterday.
Yes.
It comments to your lordship any day, my lord.
What is the date? From date of this that date.
Please,
Sir, so it will appear tomorrow. There is no difficulty.
Yeah.
No, you did not, Mr. Mukherjee, you did not hand over the slip. It will appear automatically. If you have mentioned tomorrow's date in the presentation form, it will appear. You need not hand over the slip.
Have the server copy, I would file it without the.
What is the urgency that you cannot wait?
Execution is proceeding, that
What is the date fixed in the execution?
first of August.
1st of August.
Under the emergency, I am going to the matter. And under the emergency, I am actually to the matter. There is a direction of the lordship to deposit 25%.
Always come on 2nd of August. 2nd of August. I'll ask you, those who want on 2nd of August, to hand over the slip.
Lordship, may I be permitted to mention a matter for inclusion?
You hand over the slip 2nd of August, those who want.
Permitted to mention inclusion in the list, Lordship.
Inclusion, please come on next Wednesday.
Lordship,
Inclusion, other upgradation, please come on next Wednesday.
May I permit to mention lordship?
Contested application, please don't mention now.
Yes, sir.
Please come on next Wednesday. Can you not wait till next Wednesday? Yes, Mr. Sana.
Yesterday, lordship, I have mentioned the matter, lordship. The matter was taken up by your lordship, on Monday. Due to my personal difficulties, lordship, I could not present, lordship. The date before the learned trial court, lordship, as last chance is 8th August, lordship.
So what order has been passed?
Now, lordship, amendment was rejected, lordship,
What is the order passed?
for monthly list of September, lordship.
The order has been passed, Mr. Shanlal, then you have to take out an application. If there is an order, please check up. If there is an order,
No order has been passed, lordship, only lordship.
please check up. If no order has been, then hand over the slip. Otherwise,
I-
an order has been passed, you have to take out an application.
Lordship, no order has been passed, lordship. No order has been passed, lordship.
I have not passed any order.
Been passed, lordship.
Please
I
check
have
up.
checked from the lordship server, lordship, that no order has been passed.
Please check up.
Lordship, I have checked.
Please check up after that.
My lord, the case in the lower court is for tomorrow and evidence will be closed, my lord. And one document, I want to use it as a secondary evidence, my lord.
Matter is appearing where?
Daily list, my lord.
Then 2nd of August mark করে দিন এটা
My lord, it will get frustrated, my lord. The CO will get frustrated, my lord.
Lordship, may I be permitted to mention?
One clarification, may I seek, my lord, in a matter, my lord, where my lord, at the extension of interim order stage, had extended the interim order with a direction that the matter would retain its position. Now, my lord, in the last monthly list, my lord, it was appearing as contested application. Now, my lord, in the July monthly list, it is not appearing, my lord. We have mentioned on the last Wednesday, my lord's officers has said, my lord has not directed the recent contested application to be listed in the monthly list of August.
It was prior to that it was
Yes, prior to that, it was appearing.
দেখেনি ওটা বোধহয় আগে contested ছিল থাকে translation.
To mention for a first time application for inclusion.
Please come on next Wednesday.
Your Lordship, may be permitted to mention one matter 1374 as monthly list, and also running the daily list that will be taken from 3 PM, your Lordship, as serial number 19. But the next date before your Lordship,
This,
line for 5th August, your Lordship.
Yes, call the list.
Lordship, may I pray one thing, lordship? No order has yet been, lordship, uploaded, and in the server I have already checked up, lordship.
Please inquire if it is not.
I hand over the slip, lordship.
Don't hand over the slip now. Please inquire.
May I come back tomorrow, lordship?
May I mention a matter for expeditious disposal, my lord?
Sir, can you not wait till next Wednesday?
May I make state, my lord, on
Maybe, no urgency. Yes, please come on next Wednesday. Yes, call the list.
Item number 1,
Item number 1, your lordship, I appear on behalf of the opposite party. This matter was disposed of.
Post off.
I don't know why.
Maybe some corrections is required. এটা কেন আছে?
This was disposed of by order dated 21st of January 2025.
21st of January 2025.
Yes, your lordship. Your lordship sees the order 21st of January 25. Although the matter was kept pending till the 4th of February 2025 because an undertaking was required to be placed.
Why? Compliance of direction.
Yes.
Revision application was disposed of for compliance of direction. It was directed to
But that,
because filing of undertaking.
yes, lordship, but that was also, the matter was disposed of by 14th of February 2025 order.
No, 14th of
February. That January 25, the order of
Who
transfer,
has mentioned this?
Lordship, not at my behest. Even I was little.
Please see, someone has given this. Dekhan. No signature, nothing. Signature না থাকলে accept করেন কেন? Copy of the order has been handed up.
Lordship would see this order that has been placed is of November 24,
But this was handed up, madam, in mentioning
not at my behest. I
not the other side may have. Ashwin. Submitted. Madam, one server copy of an order has been handed up. What can be done?
My lord,
You are appearing.
no, my lord, excuse me. My lord, I ought not to be mentioned, my lord. I was in the, my lord, confined in the, my lord.
No, who is in this? No, what do you want?
For application of my application for interim order, my lord, interim order, my lord,
Upgradation.
my matter is running in the list, my lord. In the
Please
combined-
come on when, can you come on this Saturday? Or mention next week? If not this Saturday, mention next week.
Extremely sorry. Extremely sorry.
Yes, who is appearing in this matter? Item number 2.
I am for the petitioner Sugam Kumar. He doesn't want to proceed with the case, so I put an order.
The learned advocate appear.
Submitted with
When?
the mentioning slip. Milord, can you check whether it is number 3?
24. Mentioning slip, where is the written instructions from your client?
The written instruction has been given with the mentioning slip only.
Why are you handing up the written instructions, madam? It's not here.
Milord, this is item number 3.
But this is item number
3, Shugam Kumar Bunia.
222 has been called up. Oh, this is an application under section 24 of the Code of Civil Procedure. So for want of determination, let the matter go out of list. Next, item number 3.
Item number 3.
Item number 3, you don't want to proceed?
No.
What is the can for?
It was for maintenance.
I can ask. Please don't hand over the letter issued by the client at the time of mentioning. Ashwin, the learned advocate appearing for the
I came 4 months. That's some at my instance, my lord. It is Joseph ke deven. My lord, I have marked it, what the correction.
corrections.
Yes. It is Joseph ke deven. My lord.
Ejectment appeal.
Yes, it will be ejectment appeal. And 15 judge within bracket IC, that is in charge. It will be taken up. And
Additional district judge 15th court in charge.
in charge, yes. And third page,
Title execution case number 4 of 2024.
yes.
That has been correctly recorded.
No, title execution, it will be
Oh, it should be ejectment execution case.
Yes. Well, I have read.
In the order dated.
Item number 5, I prefer not to only. He has not come to the petitioner, Sheikh Anwar Ali. Due to illness, he has not come to. I prefer only not to.
No, this is that matter.
Similar.
So I'm keeping it on Wednesday because the other matter has also been.
I do not know, my lord.
All right. বুধবার দিনে ওইটার বোধহয় issue involved.
Sorry, 6,
তো
7.
একটার সময়
I'm for the predictor. But I'm for the opposite party plaintiff.
7.
But
Yes.
two can application. One application was the after the order passed by this court, the pendency of the application, one of the petition number 3 died, and his name was substituted before the learned court below. that I have
Can
two.
Can two is
For my lord, the petition during pendency of the application before this honorable court, my lord, the petition number 3 died. So, my lord, their name have
petition number 4 died.
petition number 4 died. My lord, his name has already been substituted under the court below. My lord, I have arranged.
Who has?
Well, here I have mentioned in my lord the three A, B, and C.
So
Suraj
leaving
Vishwas,
behind three, Suraj Vishwas.
paragraph 4 I have mentioned, my lord.
So substitution has to be made.
Substitution has already been made before the trial court, before the last court, and that have been allowed.
So here substitution is to be made.
Yes, my lord. Or recording of names, my lord, in the interim order, my lord, can see the extension of interim order.
Can 2 of 25. This is an application.
Item number 8.
Can 3 disposed of?
Or liberty to mention, my lord, otherwise want to be disposed of.
That is already there. Why? কোনটা সেটা বলে দিন টু মেনশন তো বলে দিয়েছেন this matter.
Item number 8, my lord. 8.
Yes, item number 8.
My lord, I am opposing.
My lord, an application filed by the plaintiff in the suit, local investigation under order 26 rule 9.
Yes, it has come up for extension of interim order.
My lord.
I'm extending the interim order. What is the interim order?
My lord, it's my suit, my lord. I am
30th.
kindly fix it, my lord.
I'm fixing it.
Yes.
After hearing the learned advocates for the respective parties. Yes.
This is for extension of interim order, my lord. Earlier occasion it was taken up. I have filed my affidavit of service, my lord. My lord, this is my application.
The learned advocate appealing for the petition.
Number 10. My partition fruit, my lord, I am the plaintiff.
You have served.
Yes, my lord. Last occasion, Mr. Sukanta Das appeared. Subsequently said, my lord, that
Where is Mr. Das?
my lord, he will not appear. On the last occasion, he expressed his opinion, my lord, that he has no instruction. He has, my lord, this is my affidavit of service.
All right. So it was
Subsequently, I again served, my lord, pursuant to my lord's direction. This is the affidavit of service. They have been served, my lord, postal.
it is appearing under the in the list.
No. Yes.
It is appearing under what heading?
My lord, Musa.
Mr. Mahad.
My lord, I beg to appear on behalf of the petitioner.
Yes.
The affidavit of service regarding the application.
Regarding the application.
My lord,
Why application?
my learned friend, my lord, has filed an application for extension.
It's within time.
Yes, within time. It will going to expire tomorrow.
Who is appearing for the other side?
Initially, there was no, not
This
thereafter.
is an application for extension of interim.
Number 12.
Petitioner, my lord, extension of interim order.
I am
My
for the
lord,
opposite
kindly-
party, plenty, my lord.
Kindly see the order, my lord, passed on, my lord.
Opposite party,
But plenty of opposite party, my lord.
plaintiff opposite party.
My lord.
I am for the petitioner. my lord.
Yes.
Plaintiff.
Yes.
No, no, plaintiff can have. Amra
Oh,
plaintiff.
plenty, sorry, sorry.
We are
Your
plaintiff,
Honor,
my lord. My lord, on
My lord,
4th
sir.
March 2025, your lordship was pleased to extend the interim order. My lord, on 4th March 2025.
Item.
12.
My-
বাসুদেবপুর কন্যা করবো
4th of March.
Yes, ma'am. This is the server copy. ma'am.
এটা কোথায় গেল তাহলে অর্ডার? ও 4th of March পরে চলে গেল কি করে?
Going to expire tomorrow, my lord.
till the end of July, my lord.
After hearing the learned advocate for the
May I submit one
respective
thing, my lord, kindly
parties.
extend it and limited period and fixed, my lord. Kindly, for a limited period.
Excess of date subject to lordship's convenience.
Who's for the opposite party?
Item number 13, my lord, I am for the opposite parties, my lord. Lord, leave me granted, my lord, to appear virtually, my lord.
All
My
right.
lord, I am led by Mr. Rajmohan Chattaraj, my lord, he is indisposed. My lord, may kindly extend the interim order and my lord, may kindly fix a date, my lord, for hearing of my application for vacating.
কেন আছে?
Can one, my lord, my application for vacating.
This application, perhaps that won't be relevant for present.
What is Can 1? What is the application?
They have not.
Vacating the interim order.
Vacating interim order.
Lord.
1 of 2024. No, any order was passed on that?
No.
No, my lord.
Can 1 of 2025 এটা করার দরকার নেই করে এটাতে করে দিন after hearing the learned advocate for the respective parties the subsisting interim order is subsisting the subsisting is extended till the disposal of the civil division application list the matter under the heading contested application after 12 weeks first of the application being can 1 of 2024 shall be heard along with the civil division application.
Correct.
Excess of date will not.
So after 12 weeks, that's the date. Please calculate 12 weeks from this date. Yes, next.
14.
For the petitioner, my lord.
I am opposing the extension. Suit is of 2002 on the ground of reasonable requirement and my lord default. But since 2002, my lord, if your lordships kindly see once, my lord, the impugned order, learned judge, my lord, has frustrated.
No, my lord.
Again and again, my lord, they are taking step. Every day, my lord, they are filing applications. Order dated 28th of February 2025. My lord,
Defendant evidence has been closed.
yes. But my lord, kindly say, in all their occasions also same thing happened. My lord, every time, my lord, kindly see the impugned order, my lord. My lord, third paragraph. Further, second paragraph.
What is the suit for?
For eviction on the ground of
Sir,
reasonable.
how many witnesses you have?
Suit is of 2002.
One witness, Mr. Mahato, I am allowing the witness to be examined, fixing a date. Do that within that date. When? What is the next date fixed?
Next date fixed is for 18. 18 August.
18th of August. On that date, the witness will appear. If not, yes, any cost, Mr. Mahato, you want?
As your lords, I leave it to your lords.
Cost you have to pay.
No.
Why? Then this order shall remain.
To extend the interim order, my lord.
Extend. I will dispose of the main matter. This application under Article 220, though this matter is appearing under the heading extension of interim order, but with consent of the learned advocates for the respective parties, the main civil division application is taken up for hearing. First of this application under Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order being number 233 dated February 17, 2025 and order being number 234 dated February 28, 2025 passed by the learned civil judge junior division Kharagpur, both passed by the learned civil judge junior division Kharagpur district Medinipur in OS number 98 of 2020. 17th of February, na?
After transfer, it has been renumbered.
My lord,
After transfer,
Yes,
OS
Renumbered, actually
is
2002
of
suit.
2020.
after 18 years, they filed that amendment application, my lord.
Bhag, please don't open your mouth too wide, otherwise this order shall be confirmed. You know, by the order dated 17th of February 2024, the time petition of the 2025. By the order dated 17th of February 2025, the time petition na kore, the prayer for time at the instance of the defendant / petitioner herein was rejected, and the evidence of DW1 was closed. And what was the next? 151 for recalling. Mr. Mahato, 151 was for recalling.
No, for allowing her to give evidence.
Yes, so means actually thereafter the petitioner filed an application under section 151 of the Code of Civil Procedure for allowing the petitioner to tender evidence. Full stop. Such application was also rejected by an order dated February 28, 2025. Full stop. Where was your, what is the time petition? Initial time petition?
Time petition.
No, time petition has not been annexed.
Has not been annexed.
Only 151 is annexed, please, annexed at C.
What is the ground in 151?
Well, he is suffering for viral fever. Paragraph 1 of the impugned order. 28th February order.
After going through the application under section 151 of the Code of Civil Procedure, this court finds that an adjournment was prayed for on that adjournment was prayed for on 17th of February 2025 on account of illness of the DW1. What's up? After going through the materials on record, this court finds that the petitioner prayed for adjournment on repeated occasions, and it appears from the recording in the and it appears from the materials on record that the learned trial judge, after taking into consideration the conduct of the petitioner, closed the evidence of the DW1. First of how the learned advocate appearing for the petitioner submits that an opportunity be given to the petitioner to tender evidence. First of such prayer is seriously opposed by Mr. Mahato, learned advocate representing the opposite parties. First of, however, considering the fact that the suit is for eviction, and on 17th of February 2025, the prayer for adjournment was made on the ground of illness of the DW1. This court is inclined to grant a last opportunity to DW1 to adduce evidence subject to certain terms. First of, it has been submitted by the learned advocate for the petitioner that the next date fixed in the suit is on 18th of August 2025. Full stop. If on or before August 14, 2025, before the Independence Day, on or before August 14, 2025, the petitioner pays a sum of rupees 5,000 to the petitioner as cost to the opposite. How many opposite parties?
One opposite party.
One opposite to the opposite party herein on account of
No, my lord.
Cost, some cost you have to.
No, my lord. No, my lord. No, my. No.
Yes, Mr. Mahato, what do you say?
Kindly conduct the
Hey,
conduct of the party, my lord.
lord.
Kindly see from
No, my lord.
2002. Some token, my lord, at least should be. Some token.
No, my lord.
2000 on or before August on account of cost comma, the petitioner shall be allowed, the petitioner, the the DW1 shall be allowed to adduce evidence on 18th of August 2025. So if however the DW1, if however the defendant DW1 is found not to be present on August 18, 2025, comma, no further opportunity shall be granted to the petitioner to adduce evidence. So stop. With the above observations, CO number such and such stands allowed, and the impugned order stands set aside. So stop. It is however made clear, if the cost is not tendered within the time limit as indicated herein before, this order shall automatically stand recalled.
On behalf of the defendant.
Yes, other this is not contesting.
I've said DW1, I have not made anything more. That's out there. Yes. Yes, yes. আচ্ছা ওটা ক্যান ছিল বোধহয় একটা নাকি আগেরটাতে বোধহয় ক্যান ছিল একটা এক্সটেনশন in view of the disposal of the civil division application, the application has become হ্যাঁ যেটা আগের যেটা করলাম না 15টা বোধহয় না 14টা 14 ক্যান ছিল না ও ওটা তো ভেকেটিংটা 14 Yes, Mr. Chatterjee.
Lord, your lordship was pleased to, Lord, hear this matter on the last occasion and granted, my lord, an order of stay. And thereafter, my lord,
that is to be recalled.
No, my lord, that is to be extended. And if your lordship fixes a day for hearing or.
I'm not, kindly see once the order impugned, I'm the landlord. But the suit initiated not sometime in 2000.
I will remember this when you appear for the tenant.
Not that. Kindly consider that this can be disposed of. I cannot lost twice. On the same aspect, your lordship, my lord, has dealt with HON'BLE Boral and my lord decided my matter, explaining paragraph 17 of HON'BLE Boral.
HON'BLE Boral?
That
Devashish Pal
versus HON'BLE Boral. That not originates from
Mr. Mukherjee, but this issue is now pending before
this issue at that juncture also pending, my lord, before.
No.
It was not submitted.
No.
Mr. Chatterjee, Mr. Mukherjee, you did not submit. That matter was pending before the Honorable Supreme Court. That point of time you did not submit. I've interpreted it in one way, but I have not.
But now, my lord, the entire.
I was not informed at that point. Maybe it was pending, but it was not brought to my notice. You did not say, Mr. Mukherjee,
I would say, my lord, that it was not pending.
I've interpreted it paragraph 17 in one way, but at that point of time, you did not tell me, or it was not brought to my notice that the Supreme Court matter was pending.
Once takes up once, my lord, for my satisfaction, that second page of the order impugned. Second paragraph thereof.
No, what happened? What is the fact here?
Today, my lord, what happened? My lord, the 7(1)(c) non-compliance, the application
7(2) complied with.
7(1)(c), my lord, I say, my lord, for 1 month, 7(1)(c). My lord, this has ripened out now at the argument stage. Everything is made complete.
Mr. Mukherjee,
is one of the.
They availed the opportunity of extension in 7(2).
7(2) my lord, complied with, as I have told.
No extension.
No extension.
Within 1 month.
Yes, whatever the direction that was complied with. There was a non-compliant subsequent deposit of 7(1)(c). At the interlocutory stage, they filed an 151 application.
When?
That 151 application has been filed after the period has been lapsed, not within the period. Not time limit as prescribed under 7(1).
After how much time?
Not in the month, default is for the month of January. The application preferred in the month of March.
After the expiry of 2 months.
Within 2 months.
The interesting point, Mr. Mukherjee.
Yes, that's right, what I intend to. But instead of.
And if the Supreme Court decides, I think so.
It will be solved. So instead of, my lord, staying before your lordship's court, my lord, under Article 227, let this issue be thrashed out at the time of Milord argument, final argument, because
But
his
the
application-
defense will be struck off.
So that will be decided now. He
No,
has
at the-
participated on trial. He will not led evidences. Everything is made complete. Now it's
All evidences are
Yes,
complete.
yes.
Then Mr. Chatterjee, I will direct this point to be
Yes.
considered along with
No
the.
question of deciding a point. Milord, if he wants to, Milord, give up this point, Milord, and allow the deposit to happen, I have no problems. Let the arguments go on. Milord, it cannot,
But,
Milord, the court has said
Mr.
something
Mukherjee, only
else.
one thing, if the arguments are to be stayed then,
Yes.
arguments are to be stayed then, because what will happen? Or he said that
You
But,
give up the point, I don't.
Chatterjee,
Either
now it
way.
may be a difficulty. Under the 56 Act, he can say so.
Now he can't say so.
So,
So that is why your lordship would have to decide it. And if he wants
the
to give up,
difficulty,
that is
Mr.
fine.
Mukherjee, even if you say that I will not take that point,
No, I cannot say, Milord, I cannot take that.
Then
Milord, I have to.
but
Then-
now, whatever, so if the arguments are over, in the meantime, something happens in the Supreme Court with
It is
regard
the
to this.
tenant who has kept this application under section 151 pending. Milord,
Why-
participated on trial. Milord, at the argument stage, he pressed for this 151 to be taken up. He waited, Milord, for a time. Milord, he is a defaulter, Milord, in respect
No,
of.
Mr. Mukherjee, those are on merits. There are two aspects of the matter. First is whether such an application is at all maintainable or not. That's the first issue. That's pending consideration before the Honorable Supreme Court. If it is not maintainable, then there is no use going into the merits of that application. Second, what you are urging on merits is if it is held to be maintainable, such an application is maintainable, then merits can be looked into. So now you are arguing on the second stage itself, when whether it's maintainable or not, that is pending consideration before the Supreme Court.
And
That's
the order is, Milord, that the honorable judges don't agree with Devashish Pal, Milord, and the earlier judgment of Justice.
They have not formed any opinion.
And that is why they have said that I don't agree and send it to a larger bench, Milord, for consideration. They have not formed an opinion, they have formed a prima facie opinion. If they had not formed a prima facie opinion, Milord, there would not be an occasion to send it to a larger bench.
Subject to
By
correction,
differing
that
with-
judgment has been shown before your lordship in the
Differing
other matter. No opinion has been formed.
Milord, if they
Since there are
don't,
two-
then why would they send
Such,
it?
Mukherjee, may not be an opinion has been formed, but
Because
an amicus was
Amicus
appointed.
was appointed,
And
Milord,
for
to assist
deciding
the court.
this, what is the
Yes.
effect of paragraph
Both these,
70?
yes, both these
Yes.
two. Because
Paragraph
this-
70.
Milord,
In the
in one way or
judgment,
the other, Milord, the
Milord,
Chamaria
in
judgment has been
none of
diluted.
the judgments, your lordship.
Chamaria has been followed in Devashish.
Yes, in a bigger way.
But
Only
in
with
one
regard to one paragraph.
It has
So
been
what's the
inserted
effect
that.
of that interpretation that has,
My
only for that it has been,
But I must be candid before your lordship, though it goes against me. Milord, the special bench of our High Court in 2023, one of the paragraphs says, Milord, yes, 7(1)(c), the proviso will be attracted. Kindly
The
see that.
provision says
Yes.
so.
No, provision doesn't say so.
7(1), it
Seven-
says subsection 1. It's an
7
inclusive one.
does not, Milord, indicate anything about 7(1).
Have a look at the provision, Milord, it says.
Mr.
subsection 1.
Mukherjee, don't invite me to make some observations now.
Very well.
I will not make any observations now.
Only one
Let
thing.
the judgment come thereafter,
Only
because
one thing.
I have my own reasonings.
That I know, Milord, your lordship, Milord,
I also know that I suffer.
I have also suffered. Everybody has suffered at my lord's hands.
Milord, only one thing, Milord, your lordship kindly makes that clear, Milord, clarity that in case of this, your lordship is extending for a period, but in case
You
this
need to
thing
mention.
yes, so that we can apprise before your lordship.
It has been uniformly submitted by Track 7-1, but you argued in that matter.
We may argue.
So that is
We
because
have
he
to
was
argue
appearing for the,
clients.
appearing for the tenant. No, why?
Oh, client
এটাতে
is
কি এ আছে?
no,
N আছে?
Yes.
This one,
What's
Mr.
the-
Chatterjee.
But
It varies
For any other purpose.
No, no, my lord. Sometimes, my lord, for not filing, my lord, we have suffered.
Can't,
we are very purposeless.
Item number 16. Yes. For the petitioner. Service.
Yes,
What happened?
some delivered, others not
You are
delivered.
appearing.
Appearing for the opposite part number 326, Lordship. Extents of interim order that may kindly be
Yes,
extended.
so filed an application, can one lordship, it will expire tomorrow.
Can 1 is for extension. Put it in, can 1 extension of interim order. Every service filing code today is taken on record. Can't disposed of. Yes. Yes, who is appearing?
Lord, 17, I am for the petition.
Yes, yes.
Well, in view of your lordship's direction, my lord has served order dated 16th May
This is
2025.
restoration application.
No, 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 no. This is, my lord, your lordship's, my lord, on, after hearing in motion on 16 May 2025. Please to, my lord, grant interim order. My lord, here, my lord, petition is the defendant who contested, who filed written statement. My lord,
Every service filing code today.
Matter number 18.
For the petitioner, my lord, we could not extend the interim order for two reasons, my lord. Firstly, the interim order which was granted on the last occasion was because I could not conclude my submissions because paucity of time. And secondly, I have taken instructions from my client. They have pressed the application for injunction before the learned trial court, which was refused, and they have not preferred an appeal against that.
The entire suit is not there.
Today it is not there because Section 8 has been allowed under the arbitration.
Section 8 has
Parties
been
have
allowed.
referred to arbitration.
It was referred to arbitration on, it was
But they
passed
have
in.
accepted the rejection of the interim order by the trial court. That is my submission.
The entire suit.
They have accepted the rejection of injunction from the trial court without preferring an appeal.
No order of injunction was ever passed.
Rejected. That is what I'm telling you.
Not even rejected, my
They have
lord.
stated in the revisional application. At interim stage, it was rejected.
At interim stage, it was rejected. After they appeared, they filed an application on 5 and 8. Lord, it was referred to arbitration. Against that order will come up.
No, I will not take more than 5 minutes to conclude.
Today it is not possible.
The order was passed in their presence. At the caveat is.
Sir, you were present on that date.
On that day, my lord, lordship indicated that you will not sell in the meantime. I said okay.
Yes.
But my lord, till July, my lord,
partition.
Now the parties have been referred to arbitration.
Yes, my lord, let the arbitration proceed, my
So
lord.
where is the refusal to pass interim order?
No, they have not annexed that order.
Where is that? Show me.
Well, ad interim, it was refused. I have taken instruction.
Show me.
Well, I don't have a copy of that order, but they have written it in the revision. They have stated.
Please bring it. I am extending it for a limited period.
There was a caveat.
No,
There was a caveat on their part.
Wait,
On the court below.
Yes. You are for the petitioner.
The petitioner, my lord, on the last occasion by an order dated 15th of May 2025, my lord had directed stay of further proceedings in the suit, my lord.
You are for the opposite party. Heard the learned advocate for the.
I am suffering.
Died. Lord, profound response, some died. Lord, some.
Who died?
Profound response, Lord, 4. Profound opposite party, Lord, 4. Died.
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 You have taken steps.
Long back. I have stated. I have stated in the Lord. Have you said, Lord, it is Lord with me.
No. Have you taken steps for substitution?
I am collecting Lord database. They are not supplying.
Then the interim order cannot be extended.
My lord.
Unless you file an interim order cannot be extended, sir. It has been submitted by the learned. Evidence service
In the
filed in
execution process, they have not taken steps also.
evidence service filed in court today is taken on record. Yes, next.
Lordship, the landed advocate, Mr. Rabel, is appearing in this matter for the petitioner. Your Lordship, his cousin has passed away, Lordship. That's why he is at his native village. If can be made not this week, Your Lordship.
On the prayer of the landed advocate for the petitioner. Yes.
I'm for the petitioner, my lord. In this matter, my client engaged on senior, my lord. So senior.
No adjournment, sir. Please, please proceed. Please proceed.
My lord. I'm for the defendant petitioner, my lord, and the landlord. The tenant filed a suit for permanent injunction and declaration, my lord. And the interim order was in their favor, my lord.
Yes.
And subsequently, I made a application before the district court for misappeal, and it was against me, my lord. And
yes.
Later on, my lord, the tenant filed a mandatory injunction order, my lord. That was also challenged before the district court, and district court was in favor of me, my lord. And they challenged the matter before the high court, and high court remand back this matter for further fresh hearing, my lord. And this is the impugned order, my lord. Before going to the impugned order, my lord, my submission in threefold, my lord.
Yes.
Who is the tenant? My lord, kindly see the tenancy agreement, my lord. In tenancy agreement, page 14, they relied on the tenancy agreement. Sri Pritam Sarkar, son of Subhash Kumar Sarkar, is my tenant, my lord. Was my tenant. And the plaintiff is a partnership firm, my lord. And Pritam Sarkar is one of the partners in this firm. So they have no local standard. This is the plaint, my lord. Copy of the plaint. A partnership firm filed this case, and partnership firm never was my tenant, my lord. Though in page 15, they have stated that his business.
Where is the order passed by the trial judge?
My lord.
Where is the order passed by the learned trial judge?
My lord, in this is the order of the trial judge, my lord. And my case is that when the tenancy agreement expires, the person voluntarily.
Please give me a minute. Where is the order passed by the High Court?
My lord, kindly.
prima facie appears to this court. Not be, sir.
My lord, without ascertaining the possession, they have declared order 39 rule 7 petition is pending from 2022.
Please call the next matter.
23 blood, I appear for the petitioner, but I am aggrieved by an order passed but under section 7(1) and 7(2) of the West Bengal Premises Tenancy Act.
Yes.
Here, blood, what has happened? I have been a tenant for 90 years. Now, blood, I have been depositing the rent since 2019. But 1 year prior to
Depositing before the rent controller.
before the rent controller.
When the suit was filed.
Suit was filed in 2020. I have been depositing since
2020, when the summons was served.
Summons was served in 2020 itself.
20 itself.
Yes, ma'am.
Suit filed in 2020. Summons served. What is the date of service of summons? Now you deposited before the rent controller till which date?
Till the latest, blood. In last month also I deposited 2019, blood.
How to be
wrongly deposited since 2019, much before the suit, blood. Impose any cost, blood. I am willing to pay, blood. I am willing.
You are appealing for the other side.
Also, I am appealing for the opposite party.
Yes.
Also, they made an application for 7172, but after even making an application, Your Lordship, they are depositing with the rent control till date, Your Lordship. Till date. And kindly come to the order, Your Lordship. Page number 34, Your Lordship. It has been rejected on that ground only.
That was the sole ground.
Order, Your Lordship. On the sole ground that they have not complied with the willfully, Your Lordship.
But I am willing to pay, blood. There is no malafide on my part, blood. Lordship will impose it.
This is absolutely malafide. What are you saying? The statute requires you to deposit in court and you are depositing depositing.
No, blood, I have annexed the challans, blood. If your Lordship will kindly come.
Where is your application? Did you file the application here? 7172?
Yes, yes.
Where is your application?
Number 27, Your Lordship.
Summons received in March 2021.
Yes. Page 27, your Lordship will find the application.
27 or 29?
27.
2771, Your Lordship, 2972.
72.
Lordship, it was purely intentional, Your Lordship.
Show me the finding of the learned trial judge.
May I place the order?
Page number 34, Your Lordship, last paragraph. On the provision of challans, it appears that a challan led to rent deposit before the
Which?
page 34, last paragraph, Your Lordship, on perusal of the challans.
Page 34, impugned order. That is the impugned order. Yes, on perusal of the challans.
Yes, on perusal of challans, it appears challans relate to the rent deposit before the rent control. It also appears that the defendants continue to deposit before the rent controller, even after appearing in the suit. Section 7 of WPT Act mandates the deposit of the rent with the civil code.
This application under Article 227 of the Constitution of India
is regular and some challans are missing. The challans.
So, I have annexed all the challans.
Yes,
Lordship,
next.
kindly put me some cost, impose some cost, I'll make good the payment.
Cannot be done now. Defense automatically has its stuff off. Yes.
Great.
Yes, who is appearing? None appears for the petition at the time of call, no accommodation.
Number 25.
25 for the petitioner.
Yes.
Not challenging an order of rejection of section 36. Not kindly seize the order impugned without going into trial, without going into anything, directly rejects my application only on the ground that proceedings in a separate proceedings under 125, a maintenance has been awarded.
You are earning.
Yes.
You are earning.
Yes, I am earning.
So how are you entitled to?
For the child.
For the child.
Yes.
So what is the income of your husband?
Well, he earns 2 lakhs per month.
2 lakhs per month.
Yes.
And what is your income?
Well, I have given in the affidavit of assets.
Yes. Tell me what is your income?
88,000, my lord.
So 88,000 is your income.
Yes.
Oh, your income is 88,675 and you are claiming 88,000 from the husband for your alimony.
Yes, my lord.
And show me the finding of the income of the husband.
My lord, kindly seize page.
Husband's income is 1,36,000.
Yes,
that's the finding, not 2 lakhs.
No.
1,36,000 and your income is 88.
Yes.
So both of you have to share for the expenses of the child.
My lord, since 125 is at
No.
only
I have not yet reached to 125 stage. I have not reached that stage. I am asking you, you also have your obligations.
Yes.
So you also have to maintain the child.
Yes.
So let it be proportionate to the income. Your income is 88. He's 1,36,000. What's the ratio is coming? 136 is to 88. Please compute that.
Around 54 around. 54 around.
What is the ratio?
Oh,
So it's less than double. It's less than double.
yes.
So 2:1 ratio. So you have claimed how much for the child?
50,000.
50,000. So 1/3 you bear.
My lord.
1/3 of 50,000 is?
It will be around, my lord. Well, just give me a moment. Lord, it is around 17,000 and 16,000 and all.
16,000 and odd.
Yes.
All right. So the learned trial judge has come to the conclusion that the expenses of the daughter is 30,000
Yes.
from your affidavit of assets.
Yes.
So if 2:1, you have to be at 10,000, husband 20,000.
Well,
And under 125, how much he is paying?
5,000.
Right. This application under Article 227
For the petition.
Yes.
But, very unfortunate situation. The petitioner here is a defendant in a suit for eviction. After appearance, he has filed an application under 7.2, which was allowed by an order dated 17/12/2015. Challenging that, he has filed CO 954/2016, which was allowed, and the 7.2 application was remanded back. And after the reconsideration, an order was passed, which has been challenged by this petitioner in 2273 of 2021. But unfortunately, that petition, the learned advocate on record, after filing of that civil revision, notice was notice of direction for serving notice upon the respondents were passed. But subsequently, he has left the profession. Now, there was no communication, there was a gap. That civil revision is still pending, which has challenged the 7.2 order, order passed under 7.2. Now, in the meantime, since no the deposit was made as per that order, 7.3 was allowed.
That's challenging the order when the order of under section 7.2 was passed.
7.2 first order was passed, my lord, in 17/12/2015, which was challenged and remanded back. And this order.
No. You have said that you have challenged when the order under section 7.2 ultimately was passed.
19/2/2021.
Where is that? And that is
that
under challenge in the civil revision application.
That is challenged in a civil revision.
The civil revision is pending.
That is pending. I have checked it out. That is pending. We are taking steps.
What is the number of the civil revision application?
My lord, that is in paragraph. That is in paragraph 16, CO number 2273 of 2021.
Paragraph 16.
Yes, I have mentioned that. And I have managed that application without annexures.
This civil revision application is still pending.
Still pending, my lord.
It's appearing in the list anywhere.
No, my lord, we are taking steps, tracking the file and taking steps for. If my lord.
But I cannot take up that matter. I do not have determination with regard to that.
As per my information, only it was not been admitted. Honorable Justice Kesang Duma Bhutia, when her ladyship was there, she just directed to serve notice upon the respondents. Technically, that was not even admitted.
Then that does not amount to stay of operation. The question that arises
My lord, item number 27, for the petitioner led by learned senior advocate Ajay Devnath, my lord. My lord, we have filed a caveat, but the service has not been completed yet, my lord. So I'm for,
What is there in the main matter?
my lord,
Please,
I'm very new in the chamber, my lord. I do not have the brief with me, my lord. Kindly,
how long you are practicing?
my lord, yes, my lord, I have been enrolled in 2019, my lord.
2019, having 6 years now.
My lord, due to some my health issues, my lord, I couldn't join the court. I joined in 2023, my lord.
On the prayer of the learned advocate for the petitioner, the hearing of the civil division application stand.
But I am for the opposite party. I am taking the point of maintainability.
It's not maintainable, Mr. Vadajaji.
Yes. Order,
Maintainable.
Section 7 order passed for damages.
Now I can exhaust his.
Yes, of course. Not exhaust.
Let him say whatever points he has, we not let him take it.
Of course. Now, my lord, here.
Hotly contested matter.
Hotly contested.
Keeping it.
Section 7 order.
Fixing it, fixing a date.
Fixing it. In the meantime, nothing to.
Saturday, what time?
Huh? My lord, I am equipped with 2 judgments, my lord. I will just place it. My lord.
Share it with Mr. Vadajaji. He will come ready on Saturday.
My lord, I will do it, but it won't take much time, my lord. Section 7 order passed for damages. Their point is barred by limitation. Whatever the fact may be, my lord, limitation is issue, mixed question of fact and law. They have to prefer an appeal under Section 9. So he cannot just.
Section 9.
Of course, before the district judge, he cannot come here. No, my lord, the first judgment I want to rely, my lord.
It's not an appellable order.
My lord, kindly.
Which has been passed completely ignoring every tenets of law.
That might be one thing. Whether there is a provision of appeal.
No, the appeal will not here. It is not an efficacious appeal. Kindly see.
Why? Section 9 appeal, you are saying not an efficacious appeal.
A statutory appeal. Please see. What are the facts? Has my learned friend completed?
No. I just want to rely on 2 judgments, few paragraphs, just 4-5 paragraphs, and I will raise. Lord, can you have a look at a judgment reported in 2022, volume 17, Supreme Court cases 332. My lord, it's a case, my lord, where, my lord, there was an appellate remedy available. Lordship will kindly take, my lord, the first paragraph, feeling aggrieved.
Reference
2022, volume 7, Supreme Court cases 17 to
7 or 17.
2022 volume 17
17
Supreme Court cases
तो ब्लर होएगा जो 17 लिखा है देखा नहीं
17 तो बोल 7 बोल सॉरी
लगता कि
kindly have a look at the first paragraph. Feeling aggrieved and dissatisfied with the impugned judgment and order dated such and such.
Paragraph number?
First paragraph. Just a fact. Then I will take your lordship to the main paragraph. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by High Court adjudicator in such and such, by which High Court in excess of power Article 226 of the Constitution set aside an assessment order passed by the assessing authority, and also belated notice of demand. Kindly mark this portion because that is their case here. The state of Maharashtra and others have preferred the appeal. Now, paragraph 3, according to the petitioner, not necessarily, kindly come to paragraph 4, that without preferring any appeal before the first appellate authority, this portion is important, that without preferring any appeal before the first appellate authority, the respondent assessee, original writ petitioner, filed a writ petition before the High Court challenging the assessment order passed under the provision of the NVAT Act and the CST Act challenging entirely, and no order was passed on such and such. It was passed in the month of July 2000 and was beyond the period of limitation. And the High Court was constrained to writ petition. Now, let's straight away kindly come to
paragraph 12.
Yes. At the outset, it is required to be noted that against assessment order passed.
What is the judgment? What is the next judgment?
Next judgment, my lord, is, my lord, now they are challenging the order saying that this is barred by limitation. Now, my lord, kindly have a look, 2003, volume 6, Supreme Court cases, 675. Now, my
It
lord,
has been subsequently explained in a subsequent judgment.
Lordship, Lordship. But here I want to say, my lord, the scope of civil revisional court under 227. Now, my lord, here, my lord, the issue, it is not an appeal court, and my lord, therefore, my lord, kindly.
Which paragraph you are relying upon?
26 first.
Which difference between 226 and 227? Paragraph 26.
That. Well, here also, well, it says, well, if the appellate provision is far different than the revisional jurisdiction, in order to safeguard against a mere appellate or revisional jurisdiction being exercised in the grab or exercise of supervisory jurisdiction under Article 227 of the Constitution, the courts have diverse.
Mr. Nag, it's a discretion whether the court will entertain or not.
Correct.
It's
Now,
a discretion.
kindly have a look, paragraph 27, Roman 4. The power of superintendence under 227 of the Constitution cannot be invoked to correct an error of fact which only a superior court can do in exercise of statutory power on the Court of Appeal. The High Court cannot, in exercise of its jurisdiction under Article 227, convert itself into a Court of Appeal. Now, my lord, kindly come to 32, Roman 3. The power must be exercised sparingly, only to keep subordinate courts tribunal within the bounds of their authority to say they are obey the law, not available to be exercised, correct mere errors, such and such. Then, my lord, 38, 4. 38 subparagraph 4. Supervisory jurisdiction under Article 227 of the Constitution of India exercised for keeping the subordinate court within the bounds of their jurisdiction. When a subordinate court assumes jurisdiction which does not fail to exercise jurisdiction which does not have jurisdiction, such and such. So, well, here the case before your lordship, they are going to urge, ballot, just to indicate why I am relying on this judgment is that, ballot, they will say that this is barred by limitation. Now, the defense would be, my defense would be on fact is that they are what cities of subtenant and they continued.
Where is the impugned order?
Impugned order, lordship will find at, ballot, volume 3,
Volume 2,
248.
at page 248.
Volume 2, page 248. Well, this is a order. Now, here the question of fact is involved because the subtenant, if my lord, I get chance to file opposition, if at all lordship.
No, 248 is a letter.
The judgment begins at after 2 pages.
251 is the order. 15 July 2025.
51.
251 is the order.
Oh, this is the communication.
Page number
49. Page 8.
249 it starts, but the order to start communication. Main order
251 it starts.
Yes, 51 is final order. Normally, the appellate remedy, lordship under section 9, lordship will find both
Public Premises Act.
Yes, my lord, kindly have a look. I have, my lord, a copy. My lord, kindly. Now, my lord, section 9, lordship takes
9.3.
9.3. No, my lord, it's 9.1. 9.1, it's
9.1.
9.1 itself, it says. An appeal shall lie from every order of estate officer. Has your lordship contact?
Yes.
An appeal shall lie from every order of the estate officer made in respect of any public premises.
Or section 7. So this is an order passed under section 7.
Under section 7. Admittedly. Now, it's not only law that is involved. The subtenants continuously paid rent to Port Trust. It is their case subtenant paid, but I have documents to show that they have deposited rent in the letterbed of Martin Marsh. So, Mr. What is just client? So, the factual issues are involved. To go into the issues. And my lord, I think, my lord, here in my lord, in jurisdiction under Article 227, when my lord, the limitation is a mixed question of fact and law, my lord, I think, my lord, even if he makes out a case that it is prima facie barred by law or something, it requires to be gone into, it's required to be adjudicated in details, not only law, but also in facts, my lord. That's my submission on the point of maintainability. আর কিছু বলতে পারবো না। Maintainability বলছি, main বলি, তারপর
Please come to page 134. One, 3, 4. The trigger of this proceeding is page 134.
Mr. Bhattacharya, if you want to maintain 227, you have to come within this limited scope of 227. Please keep that in mind.
Yes.
Please keep that in
The
mind.
refusal to exercise discretion vested in a court. Despite and apart from that,
Make your submission,
apart
but
from
keeping that in mind.
Apart from that, please see the rules under the PP Act.
Yes. Rules are here. Yes.
Rule 5.
Rule 5. Yes.
Rule 5(2).
Yes.
Pausing here, from the entirety of the 25 page order, which has been served.
25 page. It's a detailed order. Detailed order.
Yes, detailed order without considering anything.
Without considering.
Without considering anything.
It has been written in 25 pages. If nothing is considered, Mr. Bhattacharya.
Apart from his personal perceptions and what should be the law and what should not be the law, whether my points, whether the points raised by us.
Who are you?
I am the original, the tenant, allottee.
You are still in occupation of that.
My case in the written statement or whatever, in response to this, in the reply to the show cause, was that first of all, I am not in occupation.
You are not in occupation.
Since 2011-12. The proceeding here, 85, is the first date.
Whom have you delivered possession while living?
To the SMPL. To SMPL, this, what else? Shama Prasad Mukherjee? Port Trust.
Show me that document that you have delivered possession to Port Trust Authority. Show me that document. By which you have handed over possession to Port Trust.
Before.
Show me, that's the end of the matter, Mr. Bhattacharya.
That is not the end. This is computation of damages.
Yes, yes. Show me, that is why. So computation of damages according to you could not have been done since you have handed over possession.
No. First of all.
No, if, Mr. Bhattacharya, if.
Just pardons me. Sometime I will try to answer whatever is passing through your lordship's mind. Maybe I am incorrect, I am trying my luck.
I'm not saying.
Please see 134. Please see 134.
Yes.
First is this notice, whereas in exercise of powers conferred. I'm sorry, I consider the damages amounting to this 40, 60, 62.
This is the notice.
Yes. Kindly looks into the period 31/10/85 to 30th April 25.
Yes.
Now, first submission to your lordship is, the matter at some stage, a section 4 proceeding was drawn up. In the year 2085, it took 15 years for the section 4 proceedings. First, attended, extensive contest, lost. We lost. Matter traveled to your lordship's court, matter traveled to the district judge's court. Ultimately, the matter put to rest in 2012 by the section 9 appeal or whatever the proceeding was. Original order is of 2002. Now from then on, we have, first of all, Milan, in response to this page 134, please come to page 136. The first submission to your lordship is, please take the trouble to come to page 141, paragraph H. This is my case. It is pertinent to note that at all material points, it is the knowledge of SMPK that Martin Bond is not in possession of the subject plot, as the said plot is in possession of several occupants, and the said occupants have been found as under. Thereafter, we have indicated. Then, it is pertinent to note that by 12 separate letters, all dated September 5, Martin Bond.
There is no arrangement between these parties.
We have not, no. In fact, there is a different, I do not know them. The fact of termination of the occupant sublessees are always known to the SMPK from the date on which the agreements were duly terminated. After such, the occupants started paying rent directly to the port trust, and such fact can duly be corroborated from the statement of account, which is available with the undersigned for the period commencing April 5, 2012, and from there, the statement of account provided by Kolkata Port Trust, it will be apparent that the said occupants have made direct payment of monthly rent to the said such and such, and eventually the status of the said occupants have been converted into direct payment. Kindly skips over. Please come to 145. Again, the same thing reiterated in paragraph N. In paragraph O, we have stated that there is no dual relationship between SMPK and Martin Bond. The purported claim is also barred by the laws of limitation. By issuing the purported notice, is trying to extort money from Martin Bond and trying to get unjustly enriched. On April 2012, the public premises appeal filed by Martin Bond was dismissed, and the said order was never put to execution, and as on date, such execution can be that the same is barred by law. It is apparent that by issuing the notice, you are trying to resurrect a dead or
this order was against
Martin Bond.
April 2012 order is against what provision of
the Section 4 order? Section 4 order made in the year 2002. Made in the year 2002. Now, thereafter, we have stated in detail. Please take the trouble to kindly come to page 147.
Yes.
Subsequently, the said SMPK.
Yes.
I just read from the last portion of page 147. Subsequently, the said SMPK had issued notices, intimation letters as mentioned aforesaid, and the said letters have been duly replied to by letter dated November 24 by the company. It is on record that the Martin Bond is neither in occupation nor in possession of any of the portions of the subject plot since long, and as such there is no scope for imposition of any occupation charges or damages.
So since long means
2011-12.
Where is, you have not specified any date?
Yes, I'll just give you a lot. 142. Please see page 149 first. Just kindly give 149. The undersigned had paid rent till July 2011 as against the said plots till such time the said plots were under the occupation of the undersigned. Relevant documents in this regard showing payment of rent are annexed here to and marked such and such collectively. From a bare perusal of the agreements, it is evident that the said undersigned has terminated the agreements long back. This is my response. Thereafter, I had appended all the.
According to you, you had paid rent till July 2011.
Thereafter, I am not in occupation.
So you are not obliged to pay rent thereafter.
In any
and, which period this claim was made?
From 85 to 30th May 25. Without there being, pardons me for saying this, what little that I have learned, there has to be some basis for 40 crores. There is no application, there is nothing. Only this notice of, I respond to this notice, I attend a particular date of hearing. Mr. Dasgupta was there. My lord, I am informed, my lord, on
You did not appear there.
Huh?
You did not appear there. You are not taken there.
My lord, my learned friend was there.
That you have said. I am asking you. You are not taken there. Yes,
That
yes.
is neither here nor there.
Yes, yes. Proceed.
My lord, that has got nothing to do with.
Proceed, proceed.
Now, my lord, in this response, apart from anything else, we have annexed certain judgments. So,
Mr. Bhattacharya, why judgments are annexing in the civil
I'm sorry, my lord, I was incorrect. My lord, I was incorrect. My lord, please see. My lord, please see page 1. 99.
Page 99.
My lord, first is that minute. Page 179 would show that this is the amount of money paid. 2 crores 56 lakhs and odd. To Martin Bond up to by Martin Bond to SMPLA. But before that, I straightway may not take your lordship. Kindly take the trouble to come to volume 1.
Yes. Page.
Please see page 81 capital P of volume 1.
Yes. 81 capital B.
Our letters, this is a detailed communication. And prior thereto, in connection with the proceedings instituted, I have on 2nd June 2025.
What is the date of this letter, Mr. Bhattacharya?
This is August 24, 2012.
August 24th of August.
This is point when I am leaving, around that time.
You are inducted pursuant to an agreement.
Yes. 1938.
1938. Till which date that agreement was valid?
1985, according to.
What was your status after 1985?
1985, they first,
What was your status after that?
For this, they declared that I am not in authorized occupation.
Or in other way, unauthorized stock.
Well, that is what they sought to, and they, first of all, approached the estate officer in the year.
At your instance, there was no attempt to renew or to extend the lease.
I won't, at least from the records, I don't find. Record, it is not there. Now, what happens is, after I submit this application, the estate officer, I file an adjournment application on a particular day before the estate officer in the present proceedings. On the first day. And thereafter, I file an application enclosing certain judgments and also tell him on the point of, only on the issue of limitation as well as alternative remedy. The judgments covered both, but essentially, before the estate officer, it was pertaining to limitation. Now, please see. 99
Initially, an eviction order was passed.
Yes. Yes, it is there.
Eviction order was passed when?
In 2000, eviction application was 22/6/2000 and eviction order is dated 7th August 2002. See that
7th August 2002.
Please see page 83 for a moment.
83.
These are undisputed facts.
And this order was challenged by you.
Yes.
Now,
Appeal, my lord, ultimately.
in section 9 appeal,
Yes, ultimately failed.
you failed. Thereafter,
In
here,
the meantime, there were revisional applications carried by me, and there was also
after that, what happened? After,
from 2012 till 2025 May, apart from my lord, one letter in 2024, which my lord was issued my lord with the quantum being 66 crores.
PP appeal got dismissed in 2012. 2012.
My lord.
Can you give me the date?
My lord, I'll just give you a lot. Lord, please see 84, page 84.
Page 84.
April 2012.
Where do I get the date?
No, I'll just give you.
84.
It's 48. Please see. Please see page 48.
Page 40. Give me the date.
5th April 2012. 2012.
So, 5th.
By the third, District
PP
Judge,
appeal,
Public Premises Appeal number 6 of 2003.
that is PP appeal against eviction orders. Dismissed. Now, position.
According to the government, it is July 2011. July 2011.
So during the pendency you left.
That is the case.
Did you bring that fact to the notice of the appellate court during the pendency of PP appeal?
That instruction I don't. As on date, just now I cannot see.
Any document, Mr. Nag, please take your seat. Any document to show when you have, because since the proceeding was pending, in the midst of a proceeding you have vacated, there must be some document to show that by how you have handed over possession to the put trust. Show me that document.
No, just now I cannot say. I can try. Definitely I can.
But it's not part of the records.
But apart from my pleading, there is nothing.
Pleading, there is no specific date also.
Well, yes, Milord, in my response, Milord, before
said 2011, long back.
July 2011, specifically.
No specific date.
Milord, not specific date. July 2011.
No document has been disclosed.
Well, let us, Milord, take for the moment, yes.
Yes.
Now, Milord, this is my response. Apart from that, I raised the issue of limitation and maintainability of the 7 proceedings before the estate officer. Now, the estate officer, Milord, serves on me on 15 July, Milord, by the impugned order.
99 টা দেখাও তারপর 101 টা দেখাও
Milord, please see first page 99.
99. That is the impugned order.
No.
That's the first day when you attend and the only day.
Milord, this is page 99.
So, Bhattacharya, you raised the issue of limitation with
Yes,
the
yes,
estate officer.
yes, and he rejected it, saying that it is not available.
Hearing ও দেয়নি আমাদের।
And no hearing, nothing. Milord, please see page 70, page 99.
If a point has been wrongly decided,
Kindly see the conduct of the estate officer, kindly. I may be wrong, Milord, kindly see page 99.
page 99. No, you had said page.
Opposite party number 1 is seeking adjournment.
No, you had said page 251 is the impugned order.
No, that is, Milord, this is prior to the impugned order. Milord, this is dated 17th of June 2025.
All right, page 99. What is this order?
So this is an application made by me seeking an adjournment.
Yes, that was rejected.
No. Enabling the opposite party to file such application. This application is made bona fide. And thereafter, Milord, on 18 June, the next day itself, I filed this application and also request for opportunity of hearing.
Yes.
This is, Milord, Milord, on 19th of June, please see page 101.
101 is 17th of June.
17th of June, signed on 19th of June.
Signed on 19th of June. Yes.
Today, fixed for hearing. Accordingly, parties were directed to place their verbal submissions. The learned advocates on behalf of Martin Bond, such and such, had placed their respective verbal submissions. The representatives had submitted, they had already filed documents in support of their contentions. We are pausing here. Insofar as SMPL is concerned, apart from that notice under 7C, at least we did not get any copy of any documents, wherefore, Milord, the fact that they are entitled to 40 crores and odd, and the basis of that calculation has been made over to us. Let them show one document. I don't have a case.
No, what is the first date you appeared before the estate?
The 17th June.
So did you say that they have not furnished any documents to you for which you cannot contest?
It is recorded.
Yes.
Milord, please allow me to read, Milord. However, that during the course of hearing, learned advocate for such and such, further the learned advocate on behalf of Martin Bond has also filed an application seeking adjournment to file application before this forum. Peruse the application filed on behalf of Martin Bond and consider the matter. It is seen from the record that both opposite party and added party had already filed their respective reply to the show cause dated 25/2025, and subsequently SMPK had also filed their comments with regard to the same. These comments not handed over to me.
Yes.
It is needless to mention
that you have submitted that you have not submitted any document.
Mention here that the public provides a procedure for speedy and summary disposal of cases. All the parties are at liberty to file written notes of arguments, if any, within 24th June. The learned advocate is also at liberty to file further application as paid for within such time as mentioned above. I shall take into consideration the respective contentions of the parties at the time of passing final order on the basis of documents filed by all the parties. No application.
So, Bhattacharya, when you appear before an authority, according to you, you could not contest the proceedings effectively because sufficient materials were not provided to you. Show me before the estate officer you raised that point. And what were the documents which were not supplied?
Page 103.
Yes.
It's on the ground of
Now, please see, this is essentially an application seeking dismissal of the proceedings before the learned estate officer. On the ground, essentially on limitation.
Yes. So that's on merit, Mr. Bhattacharya. But now you are saying that you could not contest it.
That is another limb of my argument.
I was trying to take your case within the 227 limited scope, violation of the principles of natural justice. I was trying to go through that. If you can succeed on that, that is why.
Milord, two things. First is, Milord, no opportunity of hearing was granted to me in the light of this application that I am placing. Page 102, 103, 104, the application that was filed by me on 20th of June 2025.
18 June.
20th June.
20 June আমি আবার চিঠি লিখে বললাম আমার hearing
Wait on. First is 18 June. Second is 20th June. Milord, no opportunity of hearing because 19 June he says that only file written notes. I shall decide it, Milord, on the basis of written note.
File written notes.
Yeah.
Written notes and the application.
And the application together.
That will decide.
We will decide. There is no opportunity of fair opportunity of hearing. Milord, what I am trying to emphasize on is 18 June, 17 June I enter. I pay for an accommodation on that day. On 18 June, I file an application, bringing on record and seek an opportunity of hearing, not granted. 19 June, the order is passed, signed on 19 June. Apparently, it says that file written notes of arguments and application or whatever, we shall consider it at the time of.
Have you annexed your written notes of argument here?
An application encloses all judgments, all pleadings in connection with the fact or with the issue sought to be raised, including the limitation issue, including the issue, Milord, which is.
And did you raise that point that you did not get any opportunity of hearing in the written notes of argument?
Milord, in the written order records that, Milord, page 101.
Here you have taken that point that no effective opportunity.
Milord, in the final order, kindly see.
Final order, 251.
Yes. Please see, একটু বস ভাই নির্মল একটুখানি।
Yes.
First, I request my lord to kindly seize, first is the first page of the impugned order,
Page 251.
Yes, 15 July.
Yes.
Proceedings under application such and such read with such and such filed by Shama Prasad Fort, the applicant herein praying for the order of recovery of area damages, etc. under the relevant. The fact of the case in a nutshell that the opposite party came into occupation of the port and thereabouts situated at such and such on long-term lease basis on certain terms and conditions. OP violated and condition of tenancy under lease as granted by defaulting in payment, etc. Ultimately, notice to quit was issued to opposite party on 22/2/85. Thereafter, proceedings was initiated by SMPK before this forum against OP under relevant provisions of the Act, which was numbered as 385 of 2000, which is again barred anyway. I take it, it is correct. Thereafter, OP appeared and contested the case by filing the reply, and final order of eviction passed on 7th August, and accordingly, authorized officers were appointed on different occasions to execute such eviction order till date of possession of the subject premises could not be taken over. Till date possession of the subject premises could not be taken over by SMPL. Pausing here. SMPL cases that possession, despite me raising the point that in July I have handed over, be that as it may. It is intimated by their application dated 16/5/25 that a huge amount of rupees such and such on account of damages is due and recoverable from the opposite party for their occupation into the subject plot. After considering the said submission against opposite party, this forum being prima facie satisfied with the claim has issued notice dated 21/5/25 under section 7 to show cause as to why an order requiring to pay damages, etc. Then the said notice was sent to speed post. Let us ignore it. Please see. Opposite party file. They have recorded these facts. Ultimately, please come on. On opposite party in its oral, after this will be internal page, internal page 4.
Where do I get the page number?
Right hand side corner 4, internal page 4. 5-year lordship sees,
Lordship will see order sheet number in the right hand side corner.
Order sheet number is 44. 44, 45. Oh, acha. Oh, that is the page number. No.
Yes.
Yes, page number of the order.
Order sheet number 44, let us see. Opposite party in its oral as well as written application submits that the purported notice as received by opposite party on this is illegal, and claim made by SMPK through such notice is exorbitant and also barred by law. It is also claimed that SMPK has been accepting name directly from the tenants without raising any objection or demur. Further, the fact of installation of heavy loaded such and such could not have been possible without SMPK's consent. Here it continues like this. SMPK, the petitioner in their rejoinders dated this, both against OP and the sitting occupant. Sitting occupant. I am occupant. Sitting occupant is the other, the added party. Added, who he has referred to as added.
Sitting occupants are encroachers or trespassers who are occupying without any permission. I think some notification or office order has been issued for regularizing the occupation of those sitting occupants. I think, Mr. Nag, there's a notification.
First right of refusal. There was a policy like this, but they admit that they are
right of refusal. So auction and other things, they have a right.
Right. So
there's a circular, Mr. Bhattacharya, with regard to that. I had the occasion to deal with that sitting occupants in the division.
Well, they are sitting
Your lordship is correct.
So that's a different thing altogether. So you are not a sitting occupant.
I am not a sitting occupant.
Yes.
Now please see the next page.
The only difficulty is that one vital document in your favor is how have you delivered possession. That's not coming forth before any forum, neither before the estate officer nor before this court. That's the clinching issue.
May I?
Show me, because Mr. Bhattacharya, one thing, a person who has been inducted into the property, so he, according to you, have delivered possession after 2011 or 2012, whatever the date might be. So you are a private limited company. So it is expected that there will be some document you will retain as a proof, because you know that might be they will saddle you with some occupation charges even after you have left the property. So this is the only document.
May I? My lord, I am, my lord, alive. My lord, I'll try to definitely, my lord, try to assist your lordship on that score. But before that, my lord, please pardon me. My lord, please read page 45 once. Internal page 5.
Yes.
Heard the rival arguments from both the sides and considered all the documents placed before me, including SMPK's quit notice dated 22/2/85, petition dated 22/6/2000, application for recovery of dues dated 16/5/25, and the.
Yes.
I do not know what application he is talking of. At least I have not been served apart from the notice. And the statement of accounts, opposite parties reply to show cause notice dated 3rd June 25 on record, reply to show cause notice filed by
So sitting occupants were also hard.
Yes. Not hard. They were made parties, they were permitted
They were
to give.
hard, Mr.
No,
President.
with respect, no. The next sentence will prove it.
So did they file? So
They,
what is
the next paragraph will prove it, that they were not hard.
All right.
Sitting occupant dated this.
No, is it a wrong thing? The show cause notice was also issued to the sitting occupants.
That I do not know.
This order records and reply to the reply to those show cause notices filed by the sitting occupants.
Reply to the show cause notices. I am concerned with Martin Bun. Martin Bun's reply dated 3rd June 2025 finds mention here. Finds mention here.
But not considered.
I will say that, just the next sentence will prove it. It appears that after conclusion of the instant hearing, opposite party filed 2 sets of application, one on 18th and another on 20th, seeking hearing.
Where are you placing?
Last paragraph of page 5.
Of 45.
Yes.
Page 45.
Yes.
No, last paragraph means it appears after.
After conclusion.
Will you place 2 lines prior to that?
Yes.
2 lines prior to that.
Written notes of arguments dated 24th June and the application of opposite party dated 18th June.
So they are filed written notes that was. So that was also considered.
But,
yes, next.
But no hearing conducted. It appears that after conclusion.
Mr. Nag, please take your seat. Let him exhort.
Query that the sitting occupant were hard. That is written in the order, page 44, middle paragraph.
I have gone through those pages. When Mr. Bhattacharya was making submissions, I have reached to 45 prior to his coming 45. That is why I have indicated him 2 lines prior to that.
Yes. Your Lordship is correct. It appears that after conclusion of the instant hearing, the opposite party filed 2 sets of application before this forum, one on 18th and another on 20th, seeking hearing for dismissal of instant proceeding along with other allied prayer. I must mention here that as per provision of the Act, it is the primary duty of the opposite party to file the reply or deal with the grounds mentioned in show cause. And opposite party has already filed such reply, and now after conclusion of such hearing, we are putting here this question to myself: when did he conclude the hearing?
17 June.
17 June, we had nearly 19th June is the only minutes. 19th of June 2025, he gave us liberty to file written notes of arguments and file whatever application. He did not grant a fresh opportunity of hearing. But this is apparent from this recording here. File such reply, and now after conclusion of such hearing, putting this question again to myself, the hearing did not commence to be concluded. There was no hearing. So, hearing, filing of application for further hearing by opposite party would only delay the matter and eventually defer the administration of justice. Hence, I find very little merit in the application of opposite party dated 18th June and 20th June seeking opportunity of hearing. Seeking opportunity of hearing, he denies me the opportunity of hearing. The opposite party was duty bound to file documents in support of their cases, if any, against the show cause issued by this forum and PP Act. However, no one compares the opposite party for its personal appearance, attendance before this forum. that is needed is the reply to show cause to be filed within the statutory limit of 7 days within the supporting documents in support, and it is needless to mention the taking up adjournments on one pretext or the other frustrates not only 1 day, 17 June, and the frustrates the basic spirit of the act. Hence, such application of the opposite party are rejected. Be that as it may, following the principles, I proceed to consider the case made out by the opposite party through its application already on record. So this is being decided without any hearing. Now, may I please see the question posed by him in serial number 3.
Yes.
Is one of those questions. He decides this, my lord, at page 49.
Page 49. Yes.
The judgment of the Honorable.
Yes. Yes.
The judgment of the Honorable Supreme Court is very much relevant in deciding the question whether this forum is a court or not. It was decided by the Supreme Court that Civil Procedure Code and Indian Evidence Act are not applicable for proceedings before the estate officer under this act, which provided a complete code. The Limitation Act applies to suits to be governed by CPC and Indian Evidence Act when the basic elements for adjudication of a suit are totally absent in the proceedings under PP Act. It is futile to advance any argument for its application. The judgments of different high courts, including that of Delhi High Court, will not given any opportunity to meet. I am fortified by judgments of Honorable Supreme Court in such and such. Fortified by judgment of the Honorable High Court Calcutta in such and such, with reference to judgment reported in AIR 72 Tripura, it was clearly held that proceedings initiated are not in the nature of suit, not the estate officer acts as a court. The applicability of the Limitation Act before the quasi-judicial authority like this forum was subject matter of consideration before the Honorable Apex Court by the judgment delivered by the Honorable Supreme Court in MP Steel versus Commissioner of Central Excise. Before the quasi-judicial authority like this forum, Central Excise judgment, the ratio of Central Excise ratio is imported to a PP Act proceeding.
Placed in hearing.
And this was no opportunity extended to distinguish these judgments. And straightway now, after everything, after the quoting from the Honorable Supreme Court's judgment, in my view, I am requesting my lord to kindly come to page 52 or internal page 52 or internal page 12. Does the plea taken by opposite party regarding applicability of Limitation Act in the proceedings under this act has to my considered view got no merit, as the same had already been ruled out by this forum, affirmatively citing various orders of the superior court. Further, if I consider section 25, it will also come into play against the opposite party's plea for time barred claim that under Limitation Act, because opposite party had already acknowledged its relationship as debtor, and section 25 of the Contract Act debars the opposite party to take the plea barred by limitation in the facts and circumstances of the case. Furthermore, the lease of the subject premises in question was doubtlessly determined by the landlord on 22 to 85. And then, my lord, he has decided issue number 6. This is 3, 4, and 5. The 6th issue was added parties issue.
Yes.
6th issue is, your lordship sees, the 6th issue is quoted in page 7, serial number 47, whether the added parties contention regarding grant of direct tenancy, that is the issue. The first submission to your lordship is, apart from anything else, my applications were decided having not heard me, without any opportunity. Apart from anything else, at least I am entitled to an opportunity to be extended to me on the basis of my applications filed and which were taken on record, decided without any opportunity extended to me to place and deal with the contentions raised in those applications. I am before your lordship today. Please see, the issues which were sought to be raised by me have found place in certain judicial pronouncements which I have annexed in the application. Please take the trouble to first come to.
What are the citations, Mr. Bhattacharya?
It is recorded here.
So please
Now,
give the
please see
citations.
2010 4 CLT, page 591,
2010 4 CLT, page
591 at page 205 of this application. It is a part of my application. I have appended those judgments. And it's on, apart from anything else, it's on the issue of limitation. Please see, first, straightway inviting your lordship to anything, apart from anything else, please see, paragraph 56.
paragraph 56.
56 at page 215. The estate officer does lack jurisdiction to entertain a time-barred claim. The impugned order is also violative of principles of natural justice. In the conspect of those facts, my lord, a writ petition under Article 226 was entertained. The points raised, I'll just show your lordship one by one. Please see page 208, paragraph 26. Relying on, I first say, I have got this 76(3) SCC 407 on the issue of applicability of
76.
Page, paragraph 23, page 208.
What is the citation?
76(3) SCC.
3 SCC page?
407.
This is at page 208.
Yes, it is quoted. Now, please see, the judgment is, paragraph 2 of 76(3) SCC 407. কপি দেবো না, তোকে দেবো না, তুই তো আছে এখানে লেখা আছে, দেবো না তো, হ্যাঁ না 76(3) SCC, it's quoted in paragraph 23.
Yes.
Then, the point of maintainability taken by the Kolkata Port Trust in a similar proceeding arising out of estate officer and arising out of section 7. Mr. Sannal cited and ultimately, after the discussions of on the submissions, paragraph 38. After paragraph 37. Kindly see page 210. Paragraph 40, kindly sees. I am not placing, your lordship reads it, paragraph 40.
Paragraph 40 of which judgment?
Of this, page 210. At 210.
Yes.
See then, please see 41. This has also been very recently, decided by the Honorable Supreme Court. I did not get that judgment on Article 226, Alternative Remedy, 2025, Volume 4, SCC, page 1.
State Bank of India versus Prabha Jain.
The one. I don't remember the name. Your lordship knows.
Surface Act.
Oh, I have to check. Therefore, this is one. Thereafter, please see.
No, Mr. Bhattaji, if that is that judgment, there is a distinction in that.
What I am essentially on,
Judgment authored by
4 SCC page 1. I just give you, just 1 second, 1 second. 25 4 SCC page 1, 25 5 SCC. Now, my lord, thereafter, please take the trouble to come to 212.
212, yes. So now you can find out that judgment from your gadget.
My lord, paragraph 49, Aluram is quoted extensively.
Yes.
And ultimately, my lord, her ladyship, my lord, at page paragraph 56 holds that the estate officer lacked jurisdiction to entertain a time-barred claim.
Yes, anything more?
Then, my lord, the next judgment, which is also a part of this, plus 218, that is arising out of a civil divisional proceeding, my lord. Again, the trust, my lord, and similar contentions raised. There, your lordship sees, my lord.
These were part of the written notes.
Yes. Whereas, my lord, application.
So these were not considered.
Nothing.
It is written in the impugned order. I will show.
Show me the consideration, Mr. Nag, of this judgment.
43. 43
Page?
end. Page 43 end, my lord. I'm sorry, my lord.
Page 43.
Internal page 43.
So that is running page was 251.
252.
Yes, it starts page 43.
253, lordship sees last.
Yes. No, this was referred to. Show me the consideration.
Yes, the proceeding of eviction is barred by limitation and considering the eviction.
Yes, that's their submission. In the written note, show me the consideration of this judgment.
I will show, my lord.
Yes, show me.
Consider, my lord, the issue is, my lord, I tell you, lordship, my lord.
No, Mr. Nag, please show me the consideration part. I will come to the merits.
My lord, just a moment, my lord.
Show me how these judgments were dealt with.
My lord, issue 345 was dealt with.
Yes, show me that relevant part of this, how this issue of limitation was considered.
Kindly grant me. My lordship, it starts from page 48 onwards.
Yes.
Similarly, issue number 345 are taken together for convenience discussion, limitation ground with serious condition of fact and law as well. The moot point advanced by OP in para such and such in reply, there is no jural relationship with such and such.
No, those are on merit. Show me how this time.
The one I was referring to was Tamil Nadu Cements Corporation versus Micro and Small Industries.
The judgment of
Honor
honorable
existence of alternative remedy. This is 25 4 SCC page 1, Justice Khanna's.
Now, lordship, it's from page 49, end of it.
I'll just give you a look.
Why, my lord, this is within the limitation he has given a reasoning. Well, fact is not that, my lord.
No, Mr. Nag, some judgments was referred to in the written notes. So, is the authority not expected to consider and state? Show me how it was considered. Referred to is one thing. Show me how these were dealt with.
My lord, may I just, before your lordship, my lord, on the issue, this is on merit. Before that, may I just take 2-3 minutes and then take your lordship to the impugned order. My lord, kindly come first.
Mr. Bhattacharya, anything more?
No, there are other on the issue of civil revision.
All right, then Mr. Nag, please.
My lord,
Yes.
kindly.
Yes.
Please see.
Mr. Bhattacharya, how long you will take?
Another half an hour at least. Any day, not convenient. Not on second.
Why?
So, to take at 2 lordship.
2 p.m. it's not possible. 2 p.m. other matters are fixed.
Second, 2 তারিখে মামলা করবি শুক্রবার?
না, আজকে বলছি।
না,
আজকে 2 p.m.
When?
Anytime convenient. Anytime.
Ashwin,
compilation of document.
Heard Mr. Bhattacharya. 40 minutes. 4 PM, 40 minutes.
Provided I get, well, at
4
least,
PM,
by his grace, I get at least 20.
11th August 2 PM.
4 PM,
যদি 3:30 হয়
gone. Monday, it's a Monday. Monday usually you take a resolution of 4:30.
part, don't say you, you are still a part.
No, no, no.
My lord is also a part of us.
But resolutions are not taken.
কি তন্ময় ভুলে গেছে নাকি 3:30 কথা জিজ্ঞেস করতো না?
Resolutions are taken by you.
In the meantime, till 11th, they should not.
If everything is done,
One sentence.
Mr. Nath, learned advocate, appearing, senior advocate appearing for the opposite party assures this.
It's not gone. It's not.
In the next date of hearing, if anything, Mr. Bhattacharya says 11th, he will take some resolutions. That is why in the meantime, I have said. Mr. Bhattacharya says that some resolutions will be taken on 11th.
Well, frankly, at this word, well,
In the meantime, I have said.
15 তারিখে যাচ্ছি তো
Yes, only for us matter.
grateful, grateful.
with the petitioner.
TO 2610 of 2025 stands dismissed.
Lordship, I apologize for asking your lordship with this. Your lordship, I appear on behalf of the caveat. Mr. Suddhoshatta Banerjee was leading me in this matter. Your lordship, I apologize for taking up these aspects now, but just if it commences to your lordship, two aspects, if it may.
This matter.
This matter.
I'm delivered the judgment. What
Great. Fine.
consideration now?
No concern. I am for the caveat. It's in my favor.
No, you are for the caveator.
Yes, sir.
Opposite part number 1.
Yes, your lordship has dismissed, my lord.
Dismissed.
But I've heard Mr. Banerjee on this.
Nothing more to add.
Further
Just
remains.
3 advocates appeared on that date.
Grateful.
What is it? Oh yes, whose book was this? I think Mr. Vishwarup Bhattacharya. Yes. Is his book or Mr. Nath's book? Please check up.
It's written Jishnu Shah, senior advocate. Mr. Nag is carrying these books since yesterday. I'll give it to him.
Given a copy.
But I don't know, 20, I'm for the petitioner. But plenty petitioner before your lordship, my lord. But the petitioner is a landless person, my lord. But the government of West Bengal, my lord, issued patta in favor of me. Now, my lord, what happened, my lord, the opposite party defendant, my lord, tried to dispose me from the, my lord, my lord, from my property. Now, my lord, what happened? I filed a suit along with an injunction application. Now, the learned trial judge, my lord, directed the, issued an interim order of injunction in favor of me, restraining them not to, my lord, interfere with my position, my lord, in any way whatsoever manner. Now, my lord, what happened, my lord? Thereafter, my lord, order 13 rule 2, my lord, order 13 rule 2, 3A and B, I have been complied. My lord, despite of the due notice, they did not appear. It has been extended time to time. Now, my lord, what happened, my lord? In the meantime, my lord, they have, my lord, taken steps, my lord, to dispose me, my lord. Then and there, I filed an application under section 151 for implementation of the order. Now, my lord, the learned trial judge, my lord, rejected my application only on the ground that law and order issue. Then and there, my lord, I have filed another application order 13 rule 7 to enabling the court, my lord, regarding the disposition. In the meantime, I have been disposed from the. You have been disposed, my lord. I have been disposed, my lord. My lord, that apprehension in first application under section 151, I have stated, my lord, that I may be disposed. Even then, my lord, the learned trial judge.
When have you been disposed?
Yes, my lord. Kindly come to the commissioner's report first, my lord.
No, when I am asking you, when have you been disposed?
My lord, I have stated in my application, my lord.
Yes, please give me the date. So if you have been disposed, where is the question of police protection now? File an appropriate application. When have you been disposed?
My lord, disposed during the pendency of the 151, I have not been disposed. They are tried. But after the disposition, disposed of the application under section 151, they have been disposed.
When after this disorder.
Then, my lord, I have filed order 13 rule 7, my lord, that has been brought, my lord, before the court. My lord, kindly come to the, my lord.
What order you are now seeking? If you have been disposed, what order you are now seeking?
My lord, I seek, my lord, that implementation of the order.
Pay for an appropriate application there.
My lord,
now,
sir,
please understand now. There was an order of injunction. In violation, according to you, in violation of an order of injunction, you have been disposed. That is your submission.
No, not that. Not violation, my lord. Not violation. That other remedies available. I know the lord order 13 rule 2A. I'm not.
You have not been disposed in violation of an order.
But I'm not saying disposition. My lord, I will not take the recourse of order 13 rule 2A. I want, my lord, under section 151 to implementation according to the, my lord, the Paresh Das judgment, my lord. According to the Paresh Das judgment, my lord.
Paresh Das.
Paresh Das or my lord. Paresh, my lord. I have judgment, my lord, by my lord Justice, my lord Jyotirmoy Bhattacharya, my lord. Paresh Chandra Das.
That was an injunction status quo order.
Status quo time to time extended, but it is not more than order, my lord. My order is more strengthened. Restraining them.
Strengthening.
Yes, my lord. But despite of that, I have been, my lord, disposed, my lord. Kindly, my lord, protect me, my lord. Otherwise, my lord, it is impossible. My lord, I am a, my lord, landless person.
But I am bound by my own judgment, sir.
My lord, your lordship also, my lord, in certain cases for the implementation of the order, your lordship also passes judgment, my lord. I have
expertise identity. Please show me that.
Not expertise identity, expertise order, my lord. For implementation of the expertise
order, please show me that.
Yes, my lord. Not identity, my lord. I say, my lord, in a broader aspect, my lord, the implementation of the expertise order. Your lordship directed, my lord. That is this judgment with me, my lord. But kindly, first of all, my lord, your lordship will see, my lord, the Paresh Das judgment, my lord. Then, at least, my lord, report may be called for. Learned trial judge.
From where?
From the police. What is happening in the locality?
You say you have been dispossessed. You are not in possession.
No, my lord, that time I was not been dispossessed, my lord.
How can the police now say that at that point of time you were there? Can the police say that?
My lord, at least, my lord, from the locality, my lord, it can be ascertained, my lord. And at least, my lord, some FIR can be lodged by the police.
That is a different thing. You have to go to the next building for that.
No, my lord, pending. Go to the next what will be my fate, your lordship knows, my lord. Suit is pending. What will be my fate, my lord? That will lord.
That I do not know. You are saying that police.
My lord, your lordship can, my lord.
Next building.
My lord,
I have an order there.
Otherwise, my lord, kindly see, my lord.
You can start from AIR 1986 Calcutta.
No, my lord, my lord.
You can start from that.
No,
that's the parent judgment, sir.
No, my lord.
You will not start from there. That's the parent
Paresh
judgment.
Chandra
sir.
Das is, my lord, Paresh Chandra Das is, my lord,
So prior to that,
no, not back to that, after 2010, my lord. But
we start from 2010.
yes, my lord, no,
You will not go to 1986.
no, my lord, but
All right.
kindly see, my lord. This judgment,
So
your
after
lordship knows,
2012 judgment, you will not be referring to.
my lord, your lordship knows, my lord, even then, my lord,
So 2012 judgment.
2012, my lord. Yes, 2000, another judgment, my lord. 2007 is with me, my lord.
No, 2012.
2012, my lord. And thereafter, your lordship's judgment, my lord. Some of your lordship's. 2007.
What order I have passed? What wrong order I have
No,
passed?
not wrong order, my lord.
Yes.
My lord, ex parte order. Commissioner was restrained, your lordship, for implementation of the ex parte order, my lord, your lordship. Judgment.
Oh, this was the partition commissioner was.
Restrained, my lord.
Yes.
Ex parte order for implementation.
Yes.
That was also ex parte, my lord.
Anything more?
No, my lord. Not anything. My lord, kindly, my lord, my respect to submission before lordship, my lord, to set aside the order, remand back the to learned trial judge to revisit the issue, my lord.
আগের সপ্তাহে দিলাম।
Dismissal, my lord, second time the learned trial judge will never pass any order, my lord, for the protection of the injunction order, my lord.
Alim Mullah. Yes.
Is judicated, my lord. On that ground, it will be rejected, my lord. Once it has been rejected by the trial court, my lord, second time, my lord, trial court will decline to interfere, my lord. If I file any application. If your lordship, my lord, set aside the order and direct the learned trial judge to.
Oh, 2012 volume 1 CHN. You have not brought that.
Not, I have not. I have not seen, my lord. Only, my lord, what is this judgment, my lord, I have find, and thereafter 2007, another judgment passed by Justice Torun Chatterjee, my lord, sitting in Supreme Court, my lord. That judgment I have referred.
But I am bound by my own judgment. Delivered on
your lordship's judgment, my lord.
18th of July, considering all the judgments. 18th of July.
But, my lord, this is also your judgment, my lord. Your lordship ex parte order has been implemented, my lord. Otherwise, my lord, they will float the order, my lord.
I have dealt with everything. Ex parte, ad interim, when, why.
My lord, I shall see the judgment, my lord, then I will come, my lord, come back. In the meantime, I will serve the notice, my lord.
Please take appropriate steps. If you have been dispossessed, sir, remedies are there.
My lord,
Remedies are there.
My lord, once it has been rejected by the trial court, my lord, second time it will not be accepted, my lord. That has to consider, my lord.
Implementation is not possible now. You have to take other remedies. If you have been dispossessed, sir, in violation of an order of injunction or not, there are provisions. You have to invoke that.
My lord, order 39 rule, my lord, what will happen, my lord? Order 39 rule.
I'm not.
My lord,
Have I ever said order 39 rule 2A?
My lord, no. Violation.
Have you gone through the judgment of AIR 1986 Calcutta?
No, my lord, I have not. I have
then AIR 1986 Calcutta has considered these two provisions. But you are saying order 39 rule 2 and 151. That is why I asked you. You can start from 86 Calcutta. That is in your favor. But you said I will not go to 1986 Calcutta. You will start from 1986 Calcutta is in your favor, sir. And that's the division line judgment.
My lord, I shall come back, my lord, kindly, but I shall see the judgment, then I'll 1986 judgment, I will see. And also George Sahib judgment দিয়েছি 18 July টা আমি দেখে 18 July next week I'll fix any day. I will come back, I will satisfy, my lord. This is a fit case, my lord, for implementation of the order.
Yes, for
implementation of the injunction. Otherwise, my lord, I will be dispossessed, my lord, I will not get any remedy.
You have been dispossessed. You are saying you will be dispossessed.
No. Already I have been dispossessed, my lord. I will not get any other remedy, my lord. If I file any application before the trial judge, once it has been rejected, my lord, it is my humble submission before your
lordship. The interim order of injunction, please show me. Then I have to go to the interim order. Please show me the interim order of injunction, which you are trying to implement.
My lord, 19th September, my lord.
Yes.
My lord, impugn order, kindly come, my lord. Impugn order, it has been stated, my lord.
And when have you been dispossessed?
My lord, dispossessed after the, my lord.
When? Show me your application.
The leakage. After 19th of September, my lord. My lord, it is apparent from the material on record, my lord. Also.
Give me the date, sir.
My lord,
I want to know the date.
Page 26, my lord. Kindly come to
26.
page 26, my lord.
Yes.
This is the version of the plaintiff, my lord, before the commissioner.
It is the version of the plaintiff.
Plaintiff before the commissioner, my lord.
Yes.
Even my meter has been used by them, my lord. Forcibly by my lord, evicting me, my lord. Kindly see page 26, my lord. My lord, point number 4. During the inspection of the defendant making various threats, এখানে কি হচ্ছে আমি কার কথায় এখানে এসেছি আচ্ছা দেখে নেব defendants were asking such a question to me like that the plaintiff were told that the defendants were running a timber business on their property. The plaintiff also said that defendants has forcibly evicted them from their property in spite of ad interim order of injunction. Page 26, my lord.
Section 151 for police help. Did they file any written objection to that?
No, they have not appeared in the suit also.
When you have filed that application, show me the order sheet that there was a direction to file written objection.
My lord.
Was this application taken up ex parte?
Yes, ex parte.
Without serving them?
They have not appeared. How can a serve, my lord? Even no direction was given to serve.
So ex parte can police help be granted?
But even after service of the my lord, order 39 rule.
I'm not asking you order 39 rule 1 and 2. Did you serve the application under section 151?
But how can I serve, my lord? If they do not appear, how can I serve? Unless the court has directed me to serve me through speed post or any other means, my lord? How can I serve, my lord? It is my lord, not possible because who can appear? How I can present?
Can an order of police help be granted ex parte?
My lord, police help, my lord.
Ex parte.
My lord, my lord, my case is this, my lord. I have been, my lord, forcibly, my lord, evicted, my lord, despite of injunction order, my lord. That is my case, my lord. Kindly, my lord.
May I pray for a very short passover? I am late by Mr. Aniruddha Chatterjee is engaged in court number.
He's a busy counsel. You start. Yes.
This madam,
there was a direction to serve, my lord. I
If
have
madam,
served.
a short passover, if you also. Tanmay Mukherjee is also appearing for the opposite party, my lord.
All right.
No, my lord,
Short password.
What long, I don't know. Passover. 31, yes.
My lord, I am appearing on behalf of the petitioner, my lord. My lord, I am instructed to appear, my lord, that the advocate on record is in serious condition, my lord. And doctor suggested for her, my lord, complete bed rest. If your lordship kindly keep this matter monthly list of August.
On the prayer of the learned
Number 32.
Not I beg to appear for the petitioner.
Yes.
Petitioner before your lordship is the preemptee. My lord, the only point I have before your lordship kindly takes internal page 21 of the appellate court's judgment, paragraph 37. My lord, share or entire.
What is there, Mr. Banerjee, after the Supreme Court judgment?
But it is issue larger bench.
After the Supreme Court larger bench, I do not know.
Or it is larger bench is pending, my lord.
That is why I am asking you, after the Supreme Court larger bench, can it be done? When the self-same issue was considered by the Honorable Supreme Court. So, after Chanarani, the division bench here.
Justice Aniruddha Bose.
So, the Honorable Supreme Court passed an order, thereafter the larger bench of this court, considering that passed an order. Again a special.
Again, sir.
We don't want preemption matters to be heard, let it be kept pending.
I am the preemptee, my lord.
That I appreciate. That is why you are praying for that. But there is nothing the section is very clear.
Very explicit.
Portion or share. Even if the entirety, it's not the entire plot.
Entire plot.
That's the distinction. As in the holding, it was the under the old law. What remains? Supreme Court decided, larger bench considering that decided, another special bench. There will be no end to this.
Well, as of now, let me take the benefit of.
Mr. Banerjee, learned advocate, appearing for the Yes, Mr. Bhattacharyya.
Yes, sir.
Yes.
Yeah, case where I seek expeditious disposal
Of what?
of the suit for eviction.
What is the stage of the suit?
Your lordship kindly have a look to the last two pages.
Yes.
That the petition has been filed by the plaintiff.
For amendment.
Yes. This is pending.
Amendment application is pending.
Yes.
The objection has been filed.
No. Against the amendment, no objection has been filed.
Have you annexed the order sheets?
Yes, I have annexed the order sheets.
What is the last order?
Kindly see the last order.
What is the next date fixed? 3rd September.
Yes, 3rd September.
This application under Article 227 of the Constitution. None appears for the petitioner at the time.
Lord, engage on non-senior advocate. What was not today?
Lord, tomorrow I shall not be able to come. So kindly make it on.
This is, what is this application for?
Applicant Lord for recording the name of the Lord of petitioner hearing in case of his mother, whom Lord died tested. Lord,
What is the suit for?
Lord, for
What is the suit for? What is the impugned order?
declaration that plenty was entitled to get 2/5 shares. Lord, shares are there. Lord, father died. Lord, some shares are not there. Lord, may I not get Lord to some time, Lord. Lord, one engage Lord.
Whether if I am permitted, my lord,
Let
your lordship,
Lord.
neither this suit is maintainable,
Lord, Lord,
present
whether the name of the
application
of the applicant of the petitioner hearing will be placed as executor of the will in place of his mother. Mother is the Lord pro forma defendant in the suit. Provided in the suit, Lord, as such, Lord, petitioner hearing, Lord, yes, Lord, petitioner hearing, Lord, as application, final application.
Yes, you are appealing. Yes.
So section 211 of the Succession Act is the complete answer. Your Lordship kindly sees the order once.
What is the suit for?
Your Lordship, the suit for is filed by the plaintiff, Your Lordship, in connection with Your Lordship.
You are the defendant.
I am the pro forma defendant.
You are the pro forma defendant.
Now, pro forma defendant died.
What is the suit for?
Lordship, suit for declaration regarding the share. Lordship, the plaint is at page 14. Lordship, kindly take page 20. Page 20.
Yes.
Declaration that the plaintiff is entitled to 2/5 share of the shares left by Prakash Chandra Kundu. Where, Your Lordship, I am one of Your Lordship, the shareholder, but I have been pleaded as a pro forma defendant. The issue is very small. Now, the pro forma defendant made and published a will, and the probate is, Your Lordship, still awaited. Now, immediately after the death, the plaintiff filed an application for expunging of name, and I, being the executor, filed an application to be added as a party. The trial court held that once the probate has still not been granted, you cannot be added as a party. It's clearly in violation of section 211.
Yes, Mr.
Once I am the
How that
executor,
can be?
first of all, I'll tell you what is the suit for, your lordship.
Whatever it might be, you have impeded a person.
I have
So
not
he died.
I am the opposite party number 6.
Who is
not
the
the well, what happened?
Chandra Kundu.
No, you are not representing the.
I have given Your Lordship the service to the caveat, the person who has filed the caveat.
Let the plaintiff be heard.
In 1982, in terms of the succession certificate, by the no objection of all the sharers, obtain a succession certificate. 1982.
Mr. Mukherjee, one thing is that a person who has been impleaded as a party, he dies leaving behind a will.
Yes.
Probate application is pending. Executor wants to be added as a party to defend a suit. Is he not entitled to?
No, my lord, what has been, they have referred the justice only son's judgment. Then the suit shall be stayed. You obtain unless you either you have to go for administrator pending right from the probate court, for getting prosecuted. Or what my lord Mr. Justice Anil said in a case of my lord eviction suit, where just Pushpendra Sahu my lord argued, there their lordship says, all right, unless you obtain
Supreme Court judgment is there saying the heirs as well as the executor have to be pleaded.
But that suit was stayed, the suit itself will be stayed unless that is why the court said you obtain order from the probate court. You get yourself.
When I'm staying the suit, I'm directing the plaintiffs to come.
Plaintiff?
Plaintiffs to come. You are not the plaintiff.
I am the.
So I'm directing them to serve. I'm staying the suit.
No, sir, I have no of this.
Asun. Petitioner is done.
My lord, the impugned order starts from, my lord, 2000.
You need not paste the entirety, show me relevant portion.
211, my lord, it starts. I will just place the relevant portion, my lord.
Yes.
212, my lord, last paragraph, my lord.
212. There is no pagination, internal page. Please refer to the internal page number.
Second page, my lord.
Second page, yes.
No, last paragraph, my lord, it starts from now the issue of amount.
Yes.
Assessment.
Yes.
Now the issue of amount of rent is to be adjudicated as there exists a dispute regarding the same. The defendant alleged that the amount of rent payable in respect of the suit premises is rupees 100 per month. And in support of his contention, he only filed rent control challenge and court challenge. The rent control challenge filed by the defendant reveals that the defendant has deposited rupees 300 per month since November 2009 to till June 2011. In this context, the defendant has admitted that he used to deposit rupees 300 per month as it was rent included the electricity charges. Later on, the electricity connection was disconnected. So he stopped depositing rupees 300 and started depositing only rupees 100 per month for rent only. But on perusal of the evidence on record, it appears that the defendant failed to adduce any evidence to show that the rent deposited by him before the rent control included the electricity charges also. Now from the eviction notice, that is exhibit 1, well, this eviction notice, my lord, my humble submission is, this is the earlier eviction notice which was served on my father in 2007. Now, this is nothing to do with this one, because in the year 2009, another eviction notice was issued. Well, kindly see, my lord. On the basis of that 2007 notice, my lord, this assessment has been made. Now, exhibit 1 is the 2007 notice, my lord. It appears that previously the rent was rupees 100 per month. And later on, it was increased to rupees 200 per month, but no evidence has been adduced by either of the parties to show from where the rent was increased to rupees 200 per month. But the eviction notice dated, my lord, 5/6/2007. This is the earlier notice, my lord. Itself reflects that when it was sent, the rent was rupees 200, and the rent control challenge filed by the defendant reveals that the deposited rent rupees 300 per month since November 2009. Therefore, in absence of any rent receipt and any other evidence from either side regarding the rate of rent during the period from January 1997 to October 2009, no evidence. This court, on the basis of the evidence on record, what evidence on record? Considers that the rate of rent from January 1997 to May 2007 was rupees 100 per month, and since June 2007 to October 2009, it was rupees 200 per month, and from November 2009 onwards, the rent is rupees 300 per month.
Yes.
Now, next paragraph, now in determining the environment, on what evidence this assessment has been made, 1997, from 1997. The court itself, learned court itself is admitting that no evidence has been adduced from either of the parties.
Yes. What is the dispute raised by you in the 7-2? With regard to the rate of rent, what is according to you the rate of rent?
My lord, I used to pay, my lord, 300 rupees. Thereafter, my lord, 300 rupees. My lord, thereafter, the electricity connection was taken off. Then I started paying, my lord, 100 rupees per month. My lord, the rent challenges are there. My lord, I used to pay 300 rupees. My lord, thereafter, I started paying 100 rupees.
Yes. And the learned trial judge has calculated the arrears at the rate of 100 from 1997 to 2007.
My lord.
So, and 200 from 2007 to 2009.
2009. My lord.
And that is 100 and 200.
200. The next page, my lord.
That is your application, page 50.
47.
So there is no dispute that from 1997 January to May 2007, the rent was 100.
No, my lord. No, the area rent, my lord. There was no area itself, my lord, from 1997, my lord.
I have not gone to the areas. I am asking you what was the rate of rent from January 1997 to May 2007. I have not gone to the areas. I'm asking you, what is the rate of rent?
My lord, 100 rupees. My lord.
100 rupees. And from June 2007, what was the rate according to you?
এটা কত টাকা ছিল? My lord, 200 rupees, my lord.
200. That you have admitted. That is your case. It's 200.
200.
So the learned trial judge has accepted that the rate of rent according to you, 100 from 1997 to May. So there is no dispute as to the rate of rent. Now it's the question of areas.
Yes.
So areas show me that you have paid for this month. This amount has been paid 100 and 200.
My lord, that is, my lord, I have stated in my written statement, my lord, no bill was, receipt was issued.
But you have paid.
Yes, my lord, I have paid.
But you have
Can we
paid.
see this suit, my lord?
And what is the remedy available to a tenant if the landlord takes rent and does not issue rent receipt? Is any provision there in the Premises Tenancy Act?
Yes, my lord, there is a
Have you
provision.
taken recourse to those provisions?
No, in the year 1997.
Have you adduced any evidence in 7.2 to prove your case that you have paid but receipt not issued?
No, my lord, that evidence.
End of the matter, sir.
But kindly see this suit, my lord, once the plaint, my lord, kindly see the valuation.
Yes. Sir, how a suit for eviction is to be valued? Under what provision and what's the method of valuation?
7.5, section 7.5 of the code.
Yes, Mr. Banerjee, how it is to be valued? On the earlier occasion, you argued this matter.
7.5 of the code is there. Section 7.5 of the
Yes, how it is to be valued?
13, the last month pay into 13. And that should be, as per them, it should be 300, it should be 300 into 13.
But according to it, it's 100, 200.
If that be assessed, the assessment is the wrong.
Take out an application under Order 711. Rejection of the plaint, end of the matter. Ashwin, this
Now,
application.
kindly see the suit for eviction of khas possession.
Yes, yes.
3,900, my lord, kind of plaint, page 21.
Yes, so this directions to deposit areas cannot be passed.
My lord. My lord, kindly once, my lord, kindly see paragraph 4, my lord, once, my lord.
Paragraph 4 of the
Paragraph
plaint.
4 of the plaint, my lord.
Yes.
There they have said, my lord, the 26,700 is the area rent. But against that, no valuation has been made. Paragraph 4, my lord. May I read?
Paragraph 4, yes.
Yes. That the defendant was a habitual defaulter, my lord.
No, you are not a habitual defaulter.
In payment of monthly rentals to the plaintiff at
But they have not claimed that areas of rent. They have only claimed for eviction. So they have not, this is not a money suit.
No, not a money suit.
They have stated many things in the plaint, restricted their claim with regard to eviction. This application under Article 227, thank you. This application Yes.
This is an application, my lord, seeking expeditious disposal of an execution proceedings, my lord.
Execution proceeding. Who are you? Decree holder.
Decree holder, my lord.
Any miscase pending execution?
Miscase pending, but my lord,
21 to 97 to
no, this is
101.
before the, my lord, the consumer court, my lord. 2020, my lord, execution proceedings yet to be, my lord. I am the unfortunate allottee, yet to, my lord, get the possession and registration. Pending, my lord, case filed in 2006, complaint case, my lord, decreed in my favor. They went, my lord, before the state commission, my lord, decree affirmed. My lord, they have been taking time one after the other, my lord. Okay, so your lordship will find, my lord, from the, I have annexed the entire order sheet. They also filed a writ petition challenging, my lord, the proceedings. Writ petition failed, dismissed for default. My lord, this is the way, my lord, they are dragging the entire proceedings. And just by showing that the matter is pending before the honorable court, my lord, the commission, my lord, is not proceeding.
What is pending before this court?
The execution proceedings, my lord, is pending since 2020.
No, before this court, what is pending?
It was pending.
Oh, it was pending. Future.
Because that mischievous writ petition, my lord, got dismissed for default.
Mischievous writ petition.
Because, my lord, challenging the order, my lord, I would not say this is a mischievous writ petition just to keep the, my lord, execution proceedings in abeyance.
This application under Article 227 of the Constitution.
My lord, in this,
Sometime August.
my lord, in this matter, my lord, learned advocate for the on record, my lord, serious ill, my lord, she has not come to court to pay for not this week, my lord.
24th of July also it was adjourned. Let it go out of the list. An accommodation has been paid for.
Number 39.
Yes.
39, Mr. Roy is leading me in this matter, my lord. He is the circuit bench, my lord.
That cannot be a ground for paying for an adjournment.
I have a prayer.
Yes.
Though I am not a caveator, my lord, I have been watching this proceeding, my lord, for this whole reason.
Please serve him a copy. When this matter is called on for hearing, Mr. Banerjee, learned advocate, Matter number 40.
Lordship, I am appearing on behalf of the
One
petitioner
matter
in-
was fixed at 2:30. Would it be taken up?
230.
Yes.
One matter has been left in this group. Let me see. Yes.
Lordship, I am appearing for the Board of Major Port Trust. This is a highly contested litigation. In fact,
That-
Your Lordship,
coming
you
up
already have
before.
2 civil divisions pending against in this particular matter.
There's no proceeding against.
Not
in
been
this matter
served
particular.
in this
Please
matter.
add to my copy.
There's no caveat. There's no caveat.
Lordship, but I am appearing.
There is no caveat, but cannot direct you to serve.
I bow down.
It shows that there is something you want to take ex parte order.
No.
Serve him a copy
Uh,
when this matter is taken up for hearing.
Lordship, I have a small.
We have filed this particular petition, my lord. Lord, there is an order of
What order? What is the nature of the order?
but will kindly takes up the impugned order, my lord.
Yes. Is it not an appellable order?
Not an appealable order.
Why? What is the
Lord,
nature of the
will
order?
kindly seize, my lord, page 106 of my petition.
Yes.
Lord, I have filed 2 applications challenging the maintainability of these proceedings in view of the fact that there were prior civil suit which was instituted by my client, my lord, in respect to which there is already a subsisting order of injunction. My lord, this order, my lord, is the teeth of the order passed by the learned city civil court, my lord. But my only point is, my lord, I filed 2 applications. Both my applications were not considered. The estate manager, my lord, of estate officer was
Fixed for hearing on 28th of July.
my lord, my application, my lord, if a direction can be passed that both my application is to be taken up, my lord, challenging the maintainability since, my lord, there is a subsisting order of injunction, my lord, we'll be more than, my lord, pleased, my lord, with the finding of that effect.
Where is your application for maintainability? What is the ground of maintainability?
But we'll kindly seize, my lord, page 82.
82, yes.
But 82 is my application.
Yes. What is the ground challenge?
The ground is, there is a subsisting order of injunction. But parties, but there was a prior suit which was filed, my lord, in respect of which I have claimed, my lord, under a contract, I have claimed tenancy rights. But an order of injunction.
Tenancy right.
Yes. But the order of injunction granted, my lord, in 2007, the said order was, my lord, confirmed in 2019.
Which tenancy rights?
But we'll,
Under which act?
but we'll kindly seize the order once.
I'm asking you. Under what provision?
But there,
under which-
there was an agreement between the parties. Now, under the agreement, we were directed to deposit a certain sum of money, my lord, in order to become a direct tenant, my lord. We have deposited that money, my lord, no objection made. In fact, that is being recorded in the order also. My lord, 2 years
There was
later,
only an agreement.
there was an agreement. My lord, I'm claiming a declaration today in respect of that agreement, my lord. Prima facie, I have been able to show that there was an agreement in the consensus, my lord, of the respondents, my lord. No objection. They have, it's been recorded in the order. I've annexed those particular orders also. I have filed a suit, my lord, seeking declaration in respect of that agreement, my lord. I have been granted an ad interim order. That ad interim order has been.
What is the declaration you have sought for?
The declaration, my lord, will kindly cease. Lord, the plaint is annexed.
Yes. Specific performance.
Specific performance.
Yes.
And in respect of this, my lord, I have also filed an application under Order 39, Rule 1 and 2, my lord, injunction granted prima facie. My lord, the order of injunction was confirmed in the year 2019. There were several proceedings that was initiated, my lord. My lord, ultimately, my lord, there was an appeal order which was, my lord, an order which was appealed against, my lord, wherein, my lord, it was found that even if in the event, my lord, any proceedings have to be, my lord, initiated, my lord, a fresh proceedings have to be initiated, my lord. It cannot be on the basis of the subsisting case which is already pending between the parties, my lord. That order I have also enclosed it with respect my petition, my lord. But may I have your lordship's leave, my lord, to permit my senior to, my lord, make submission.
Serve him a copy. The petitioner is directed to serve a
Only
copy
one
of.
thing, my lord, I'll tell your lordship, my lord, the urgency with regard to this is that, my lord, what has been done? If you
Please serve him a copy.
my lord, kindly gives me, kindly, my lord, kindly. And I know, my lord, I know what is falling from your lordship. My lord, the difficulty is that, my lord, the Kolkata Port Trust or the SNPK right now, my lord, the Shyama Prasad Mukherjee Port Trust, they have not passed an order whereby they have stated, I have filed 2 applications there. In these 2 applications, I have stated, taken the point of maintainability of the proceedings, and I have asked for documents so that I can file an effective reply to the show cause. Not giving documents is violation of natural justice.
What are the documents you want?
I'll tell you, Lordship. In fact, very interestingly, if your Lordship sees.
So will be later or any document which states that which is the document you require from them.
We have filed an application to that effect.
Show me that. I want to know what are the documents you require.
And also, the point of maintenance.
Sir, please show me that. I will ask them to provide those documents.
And also,
please show me that first.
Very good.
Also, we come thereafter. Please show me that. What are the documents you want?
Kindly, if your Lordship takes page 99, the application.
Yes.
Your Lordship will find, kindly sees paragraph 4. Very interesting case, I am a sitting occupant.
You are a sitting occupant.
I am a sitting occupant.
Unauthorized occupant.
Now
you don't want specific performance. Now you have become sitting occupant.
I'll tell you, Lordship, why. Interestingly,
sir.
Kindly gives me one
Interesting points I will hear.
kindly gives me 1 minute. 1 minute's time. I'll not take more than that. I'll not take more than that. Firstly, there was opposite party Gauri Shankar Jute Mills, against whom proceedings were initiated in 2000.
A copy.
I difficulty is that the matter is kept on Monday, 11th of August.
Nothing.
They have asked to file reply to the show cause notice dismissing my applications.
File the show cause notice.
My applications have
without prejudice. File the show cause reply to the show cause.
I would not be able to without documents. Without
whatever documents.
And the point of maintainability has to be heard first. A 390 of 2000
without prejudice. Otherwise, I will have an impression that you are shying away from filing reply.
Of course not, This file is a very good case, I have in hand.
That is why file. So, that you have a very good case, you have a very good defense. So you can file a reply to the show cause. File a reply to the show cause without prejudice.
Reply to the show cause, I'll tell you, Lordship, very frankly. Today, if the proceedings goes,
whether to file, I'm not saying anything.
If the proceeding goes, 390 of 2000 cannot continue. 390 of 2000 cannot continue.
Petitioner submits that. I will hear both of you.
Very good. Very good.
Yes.
1/6 minute, then I'll come back.
On the fixed matters.
Daily list item number 114.
Yes.
In this matter, I lordship, I was appearing for the petitioner lordship, but
you was appearing. You are not appearing now.
No more, because the brief and the NOC was taken by the petitioner as the notice was issued over me lordship, and I have taken the notice for mentioning.
Kindly hear for a moment, my lord. What happened? Unauthorized construction made by them, thereafter before the special official building, thereafter before the municipal building tribunal, all each and every forum against this unauthorized construction. Then without implementing us as a party, they moved on application before this and obtain the order, stay order.
I'm vacating the stay order.
Yes, my lord. At the same time, my
Already
lord,
vacated by
at the same time, my lord, direct Kolkata Municipal Corporation to act in terms of the provision of the law.
I'm recording that there is no stay order, so corporation will be free to proceed.
My lord, my lord, retired school teacher before this honorable court. My lord, the only thing, Mr. My lord, the only thing, my lord, the corporation may not act on the basis of this type of, my lord, certain manner the
Mr. Chakravarti, when the learned advocate says that he does not have instructions, I cannot discuss it for.
Yes, my lord.
I'm recording his submission.
Given objection. Yes, given no objection.
Yes, so there is no stay order. So I'm recording that parties will be at liberty to take appropriate steps. You are for the corporation.
Corporation.
Take steps. Nobody is stopping you.
Only thing, my lord, some influence is being exercised, my lord. That's why the police.
They are appearing.
Not in position.
Mr. Banerjee, why your client
I
is
have
being
the coding
influenced?
I have the
Why your client is getting influenced? You proceed in accordance with law. Ashun,
Since my lord,
this
Lordship, I for the petition, Lordship. In this matter, Lordship, I am praying for expedited disposal of the proceeding, Lordship. The petitioner. of the matrimonial suit, Lordship. The petitioner before your Lordship.
Who are you?
I am the husband, Lordship.
Any alimony order?
No, Lordship, alimony order is there in the Lordship maintenance case, Lordship. They have filed the one miscellaneous case. Kindly come to the page 31, Lordship. I first.
Miscellaneous case is pending.
That is also pending, Lordship.
Yes, this application under Article 227 of the Constitution of India is at the instance of the husband.
They have taken time, several time, Lordship. The wife
Is at the instance of the husband paying for a direction upon the
time, Lordship.
Learned Judge Family Court at Asansol Sodor, District Paschim Bardhaman, to dispose of the matrimonial suit number 93 of 2022.
12 days they have taken more than
expeditiously. First up, the learned advocate appearing for the petitioner submits that the wife opposite party herein is taking adjournment in the matrimonial suit on frivolous ground.
There is no progress in the investigation proceeding, Lordship. There is no progress in the proceeding, Lordship, till date.
There is no progress in the
proceedings, Lordship.
He further submits that no effective progress in the matrimonial suit has been made till date. First up, paragraph, in view of the order sought and proposed to be passed, there is no necessity to direct. Yes.
The petitioner is the husband before your Lordship. He filed an application under section 25 of the Guardian and Wards Act. Thereafter, he filed an application under section 12 of the Guardian and Wards Act. I want to take my daughter for treatment to CMC Vellore. That was turned down. Lordship, kindly see page number 66 once.
Page?
166.
What is the impugned order? Show me the impugned order.
Yes, Lordship. Order dated
24th of January.
Yes, Lordship. Rate for temporary custody was given. That is at page number 65. Although she is not sending the daughter regularly, and the most important thing is I want to take my daughter for treatment. Even her mother goes, if anybody goes from her house, we have no difficulty. But let that be done because she is suffering from hearing problem, and that may.
The learned advocate appearing for the petitioner submits that the minor child is suffering from serious serious Yes, who is appearing?
I'm for the petitioner lordship. I filed this application for expeditious disposal
Of what?
of lordship. Our application filed in 2022 under section 7 and 9 of Guardianship and Wards Act, read with section 6 and 13 of Hindu Minority and Guardianship Act for child custody lordship at Act 8 case lordship miscellaneous. If I may bring your lordship kind attention to page number 27 lordship.
What is the next date fixed?
Lordship, today is the next date fixed, and I have received instruction that wife is today also she is absent, Lordship. In every occasion, she is taking adjournments. Kindly to Lordship.
It is for cross-examination of PW1.
Lordship, yes, Lordship.
This application under Article 227 of the
In item number 170, I appear on behalf of the opposite party. My lord, Mr. Ranjan Ray is on his way, man. I'm
Strongly oppose this. No, nothing. Last time,
can we conclude it?
After 3 months. Last time when we also
talked about it today, there's an I'm not reference.
No, I am one thing. On the last day, this is the father who is not being able to see the child. He came, there was no caveat, asked for a copy. My lord, kindly see your lordship last order once.
All right, first item, 2nd of August.
Just do something. Your lordship,
can an order be passed? He's paying for a.
No, I am not saying that. Kindly ensure that it is taken up tomorrow, day after tomorrow.
Come on Saturday.
I can come, but no, the others will leave me. Leave me allowed to do.
See the number of mentionings today. All are willing to get the matters hard on
20.
Petitioning slip a list.
On 20 April,
all wanted to do it on 2nd of
20 April, matter to appear on 29. To submit a copy 20.
Yes,
October, July, 3. I some 4 times. I'm not able to see my son. Let me come back tomorrow morning. Let it appear in the supplementary list, but I have nothing to say. Let him come.
You have nothing to say, then I'm dismissing it.
Kindly. Let me come back tomorrow morning. In the supplementary list, I'm not being able to see my son. That's the only thing.
You really want to see your son?
Yes, of course. There was an order that I would go to the mother's house and visit. But there was some problem in my wife's house. I prayed for change of venue tomorrow. The supplementary list. The supplementary.
It is appearing in the combined list.
Combined list. Combined list.
It happens with the busy lawyers. They do not find time to look to the list where it is appearing. That happens. Yes, call the next matter.
Item number 223.
Well, I appear for the petition in this matter, my lord. Supplementary affidavit. My lord, this is completely a non-adversarial proceeding, my lord. I had moved the matter earlier also. My lord, subsequent to this probate application, I would put a line of code, my lord. The matter was.
What is the impugned order?
My lord, the impugned order your lordship will find, my lord, at page 14 of my application.
This will was placed in the safe custody. What happened? What is
Safe custody, as in, my lord, there was an application made akin to, my lord, order 7/10, where the entire case records were returned, but the original was sent to the district judge. Instead of, my lord, since the
now we are filed before the appropriate court.
my lord, I could not have, my lord, the original has been written to the learned district judge. It was sent to the learned district judge in non-compliance of the provisions of 5 of the civil rules and orders.
All right, come tomorrow.
আজকে ধরবে না
Will it be?
Item number?
Item number 34, I am appearing before 35, that's why I cannot appear during that.
Can that be a ground for adjournment?
No,
It has been dismissed for default. What has been done?
I think I have not heard the matter, that's why.
কি হয়েছে? What can be done? Engagement in other court cannot be a ground.
I know.
tomorrow ভুলে গেছে
Stop.